Town Council workshop meeting to order with our special guest, Eric Scheidel, who is the General Counsel of the Municipal Association of South Carolina. We have the agenda before us, the topics, but as discussed with Mr. Scheidel, the intention is really, he will kind of provide an overview of each of these topics, but I think the idea is to generally have a discussion about them rather than kind of a detailed canned presentation. I would simply note that I've had the pleasure of having a fair amount of interaction with Mr. Scheidel. He's presented to the council previously, but I've reached out to him on a number of occasions regarding municipal governance related issues, and have found him to be an extraordinarily good resource. Because the association represents all municipalities in South Carolina, he's as knowledgeable about municipal governance issues as anybody there is in the state. And today we hope to draw upon that expertise. Eric, the floor is yours.
Good morning. Thank you, Mayor. Good morning, Council. It's nice to be here on a Friday. Lovely weather today. So we're going to do a form of government presentation to start. And we have canned presentations for this, which I don't think would be very helpful in this context that we would give to any council. What I do find really helpful, though, is to give you some historical background. I hope you find this as interesting as I do. It particularly helps to have this background when you're looking at South Carolina cases or legislation to know in South Carolina where it came from. And so some background, general background, you may know this, the federal Constitution is silent on local government. The federal Constitution doesn't say a thing about local government. The relationship under the federal Constitution is between the federal government and the state governments. And so states essentially have enormous latitude to determine how their own local governments work. And in South Carolina, you may or may not know this, but prior to the 1970s, the way South Carolina was run is local government was run by the legislative delegation. There's 46 counties in South Carolina, and the legislative delegation system was each county had one senator, and each county had a certain number of representatives, but their area of representation was determined entirely by the boundaries of the county. So you could say, for example, in Charleston County, this is the legislative delegation. They have complete control over Charleston because the people who vote for them are confined to Charleston County. Does that make sense? And so for decades, and also you have to keep in mind that South Carolina was an agricultural economy at this time. So there wasn't a lot going on, and counties didn't have a lot to do. Your budget would actually be approved if you were a county. Your budget would be approved by your legislative delegation in the State House. And they would do what was called a county supply bill. And essentially, everything would happen at the State House level. Well, two things happened. Let's say three things happened. The first thing that happened is the nature of the economy changed. South Carolina became a textile state and a manufacturing state in a lot of ways. That creates a lot more demand for local services than the historical rural economy. The second thing that happened is there was kind of a national movement. These words had different meanings at the time, but the progressive movement, Woodrow Wilson, and the idea was we want competent administration, we want local control, and this idea, like this kind of philosophical idea of home rule for municipalities in particular became more important. But the third thing, and in South Carolina's case, the most relevant thing that happened is the United States Supreme Court, you probably know this, in Reynolds v. Sims, a 1960s case, establishing what it meant to have one person, one vote, said you can't have, for example, 46 senators in South Carolina, one for each county, because the senator from Greenville County is going to have a significantly higher number of people voting for him than the senator for Hampton County. That was a surprise to everyone. It's interesting to look back and realize that as late as the 1960s, the equal protection, one person, one vote did not apply to local government. But 1960, I'm trying to think, I guess Reynolds v. Sims was 64 or 65. And they said, like, both houses of the bicameral legislature in a state have to have proportional representation. And the argument was made, well, the United States Senate is not proportional, right? It's 2 senators for every state. And so why can't we have senates that are non-proportional? And the Supreme Court said, we don't know, you just can't. And so you had to radically reorganize South Carolina government, which is that you had to now have proportional representation both for senators and state representatives. And you'll see an obvious problem. Well, if you do that, then how do you run the county legislative delegation system? Because the lines are no longer going to match to the counties. Everybody follow me? And so what that means is your senator might cover multiple counties. If you're in a lowly populated area, they may be multiple senators that partially cover your county. And so in the 60s, you know, they're trying to figure out, what do? We have these currents of industrialization, urbanization, and we also have this kind of administrative mess that's coming out of the one person, one vote rule. So what happened is the home rule study in South Carolina. Have you all had a presentation on home rule before?
We have not.
Okay, so home rule is, when you look at local government, and I really think this is helpful to understand the way South Carolina works, is there are basically, nationally, there's really three approaches to the way local governments can be set up. And by far, two of them are the majority approach. One approach is what's called Dillon's Rule. It's named after a judge, I think in Illinois or Iowa. It's probably Illinois, Judge Dillon, who wrote this rule in the 19th century and said, when you're looking at the powers of local governments are creatures of the state, and they have only the powers that are expressly given to them by the legislature. They can only do the things that you tell them they can. And prior to this period that we're talking about, South Carolina was essentially a Dillon's Rule state, but they were in even more than Dillon's Rule state. They were legislative control of everything. They may occasionally give counties certain powers. So if you went back to the county statutes in and I know y'all aren't a county, but this is how you express the issue, is looking at how counties did it. They might have had 5 or 6 statutory powers, and that was it. That was all they could do. Home rule is the opposite. The presumption in home rule is basically you have all powers that are not taken away from you. You see what I mean? Just logically, in Dillon's Rule, you only have those powers that are expressly given to you. In home rule, you have all those powers that are not expressly denied to you. And those are the two major approaches to local government. There's a third, which is called the charter city approach. It's not relevant in South Carolina. We have no charter cities, but it's helpful to understand this. Some states have what are called charter cities, which are essentially separate sovereign governments. They form a charter, the government is formed, and they become, I don't want to say a co-equal sovereign, but they become a separate, independent government with limited regulatory oversight from the state, but they operate under their own charter. There are no charter cities in South Carolina. It's not a thing, but it's going to help understand what we're talking about. So here you are, 1960s in the South Carolina. They're saying we're behind the rest of the country in a lot of ways, but we're trying to catch up. We're urbanizing, particularly in Greenville at that time. The upstate was very heavily textile and industrial. There were other pockets of industry, and we were growing. Plus Reynolds v. Sims. So in 1967, they pulled together a constitutional study committee. My former colleague, Mac McQuillan, your town attorney at Haynesworth Sinclair Boyd Lawyer, I used to work with Mac at Haynesworth, and one of our name partners, UG Sinclair, was on these study committees and drafted most of, not drafted, but, well, he did draft. In fact, Mr. Sinclair drafted most of the home rule acts that came out of this. So you're in good hands with Mac. He's in the historical lineage of how this happened. They formed the study committee in 1967. Committee reported out. There were some, this is kind of a seminal event in South Carolina history. And in 1972, the General Assembly proposed amendments to the Constitution to implement home rule. The critical thing, we're not going to go through all this, but Article 8 on local government said that was a new article of the Constitution and said this is how this works. Here are your options. And then the General Assembly, and that was approved by the voters in 1973. In 1975, we approved the Local Government Act. The Local Government Act, if you wanted to see pretty much everything it says for municipalities, you'd look at South Carolina Code 5-7-30. That is the Home Rule Act for municipalities. And essentially what it says is you have all these powers. And it's, this long, and it's basically a grant of power. You have the police power. You basically can act in the general interest of your citizens for their health, welfare, safety, security, and convenience, and we are now a home rule state. Now, why does all this matter? First off, because it helps you understand what your own powers are. Again, you're not a charter town. You are a part of the state. You're a political subdivision of the state. There's interesting, like, why did I tell you that the federal Constitution makes no provision for local government? It means that you're not a sovereign entity separate from the state. So you'll see these cases, for example, like what if the state of South Carolina passed legislation saying we're appropriating the Kiowa Island Municipal Center for these purposes? And you said, well, you can't do that because that's a taking. The courts would say, no, it's not a taking because you're the state. You see what I mean? You're part of the state. But in the ordinary course of affairs, you're still a home rule town. So you can do pretty much whatever you want, as limited by the law. We'll talk about that a little bit more in a minute. So that's what I'm saying. Let's see, am I on the right slide? Yeah. So municipalities are not sovereign bodies with inherent powers. Your political subdivisions of the state. The General Assembly says, here's the particular powers you have. To protect your autonomy, there's this thing called special legislation. The Constitution prohibits special legislation from the General Assembly, and what that means for your purposes is the General Assembly can preempt you. For example, the General Assembly could pass a law that says it is illegal to ban short-term rentals. We'll talk about that as part of the items on the presentation. But they could pass a law that says it is illegal for towns in South Carolina to ban short-term rentals. What they could not do is they could not pass a law that says it is illegal for the town of Kiowa Island to ban short-term rentals. That's special legislation because it targets an individual city, town, county. And we talked about counties a lot because what the act really did, the Home Rule Act, is gave counties a lot more powers. Municipalities, for various historic reasons, already had more powers than counties. Intuitively, you can think about why, which is because y'all have more to do, particularly than a rural county. If you look at, what do cities and towns do? Well, historically, it's always been the case. Cities and towns are formed because you have population density, right? As opposed to an unincorporated area of the county. You have population density, and what comes along historically with population density, you need a sewage system instead of septic. You probably need more thorough law enforcement than a sheriff's office. You need to do more things. You probably need to do trash pickup, items like this. So cities already had more powers than counties, but the act gave counties a bunch more powers. Yes?
You mentioned the General Assembly. I don't know what that is.
Oh, that's the state government, the General Assembly. So our state government in Columbia is organized. It would make complete sense to you. The General Assembly is the two houses of the state. It's the equivalent of the state Congress. So for example, in South Carolina, when we talk about the General Assembly, it would be the state Senate and the state House of Representatives. Yeah.
If I can just ask, if you ask questions, if you can just please speak in the mic since it's being live streamed.
And we made previous reference, Madeline, to the fact that Representative Spencer Wetmore is our representative in the House in Columbia at the state legislature. Senator Chip Campson is our senator representative for this area.
Yeah, and I should say, because Mayor Belt is telling you who your legislative delegation is, the concept of the legislative delegation still exists. There's still a Charleston County, Berkeley County legislative delegation in the General Assembly. What's different now is their areas don't overlap. Some might be here, some might be there. And without getting into the politics of it, they become even more strange when you look at, in a non-editorial use of the word, gerrymandering. When you look at our House districts now, they don't make any intuitive sense. They're being drawn because the General Assembly wants it. Anyway, that's too political, but the delegation still exists and they still have certain limited powers. Like the delegation may appoint the members to the Charleston Aviation Authority. They may appoint they have these limited powers, but in the old pre-home rule world, they ran everything. So our form of home rule, what the act says is, here's the powers you have. And then it says all local government powers are construed liberally rather than strictly. And so you have the following powers: those powers that are expressly given to you by state law, those powers that are fairly implied from state law, those powers that are not prohibited by state law. That is the concept of preemption. Y'all familiar with preemption? And preemption works both at the federal level. If the federal government says, this is the law nationally under the Supremacy Clause that trumps state law, and under this kind of idea of preemption here in home rule, if the General Assembly says something, it trumps you.
And Eric, we're dealing with a specific preemption issue right now in the town of Kiowa Island, and I think the folks are generally aware of it. We have had issues, concerns with regard to our native bobcat population, and their health and well-being has been impacted by the use of second-generation rodenticides. The town of Kiowa Island would love to be able to enact some ordinance and able to address this problem.
Right.
But unfortunately, well, unfortunately from our perspective, there is a state statute that preempts municipalities from enacting any ordinance that was in the jurisdiction of a department of the state, effectively Clemson University, to be able, who regulates rodenticides and other related issues. So we've actually had conversations now with, is there a way to get around that? What kind of waiver authority do they have to now enable us to potentially do something from a regulatory standpoint? But that's an example of preemption that we've had to face squarely recently.
And if y'all are, I mean, and Mayor Bell, I'll let the council determine the agenda. We could detour into a general talk about preemption now, because we talked.
That's all right. I mean, I just, this is one that we're, again, we are somewhat familiar with the whole issue with regard to preemption.
Right, right. And that's number 3 on this bullet point. Preemption is not prohibited by state law. And number 4 is a subset of preemption called not inconsistent with state constitution and state law. I mean, very briefly, since Mayor Belt raised the issue, because I think it's interesting, and again, y'all can interrupt me, ask questions at any time, but it always, for me, the way I think, it helps so much to understand the context and concepts of these kind of things before you approach specific questions. So just on preemption, when you're thinking about your relationship to the state, there's 3 kinds of preemption. The first is called express preemption. And to give an example for this, express preemption is when the superior government says you can't regulate in this area at all. South Carolina guns are express preemption. There's an act in the state code that says you cannot regulate guns at all. You just can't. So they just come out with that. The second type of preemption is called implied field preemption. And implied field preemption is the General Assembly has enacted a comprehensive scheme that indicates that they want to control that. This is probably the case when you're talking about the issue you're talking about, is if there are state health, DHEC regulations, a DHEC scheme. Examples of implied field preemption might be, they typically arise in just highly regulated areas, insurance business. It used to be the case fireworks, because those were highly regulated, down the list. And the court would look at that and say, look, the General Assembly passed all these laws, and so we think they want to occupy the field. And then the third kind is called conflict. And conflict is number 4. Conflict preemption is you just pass a law that's different than the state law. And if you have a law that's different than the state law, if the state law says it's illegal to sell cannabis-related products, and you say it's locally it's okay in Kiowa Island, the court's going to say no, that conflicts with the state law. So those are the types of preemption. Again, I think it just helps to have those concepts. But that's how you relate to the state government. Under the Home Rule Act, all powers of the municipality are vested in the council. Under state law, the council as a body is considered to be the town. Does that make sense? Like when you're looking like who is the town, it's the town acting through its duly appointed council. And so there are case law on that, but for us, so we're finally getting to the question about forms of government. I hope that was helpful, but one of the things they did, prior to home rule, the General Assembly could say, town of Kiowa Island, this is your form of government. They would pass these things, local legislation, and so every city and town was different. Some had housing authority, some didn't. Some were, they had weird forms of government. How was your budget approved? And that would all be done under local laws. But when you pass home rule, you say, well, look, if we're going to have home rule and no special legislation, then every government in South Carolina needs to be organized the same way, every local government. They need to be organized under a comprehensive scheme, general law instead of special law. And so they said, the constitutional amendment said, if you're going to reorganize local governments, then you need to give them up to 5 ways, up to 5 forms of municipal government. And the Home Rule Act recognized only 3 forms. They had the authority to do up to 5. There's other options nationally besides how we do it, but in South Carolina, they picked 3. And the 3 they picked are the mayor-council form, the council form, and the council-manager form. They're all fairly self-explanatory, but we'll talk particularly about mayor-council. The real difference, council has essentially the same powers in every form. The difference is who's acting as the executive or administrative officer for the city or town. I think it helps, sometimes it's confusing, but I think it helps to just think about your childhood civics lessons on separation of powers, that there is the legislative branch, the executive branch, and the judicial branch. In all 3 forms of government, of course, the council is going to be the legislative branch. But then you have the executive branch, who exercises the executive power of the city or town. The judicial branch is the same in every form of government. You have a municipal court if you have one. Magistrate can handle your municipal court cases. But where the action is on this issue is who has the executive power of the municipality. And the idea, the conceptual idea, if you went back to Woodrow Wilson and the local government progressive movement in the 1910s and 1920s, the idea, well, I guess it'd be the 1900s and 1910s. The idea is that as cities and towns become more sophisticated, they have larger populations, they have more advanced economies, the larger, and I mean, sophisticated, I hesitate to use that word, more complex governments. If you're the city of Philadelphia, you're facing different problems than for example, the town I grew up in, the city of Greer, population 6,000. At the time, it's grown a lot since then. And so what the progressive movement said is, look, we should have a professionalization. We should have a civil service. We should have a professionalization, and experts should do the things that experts are supposed to do. You'll be aware, again, without making too political of a point, that issue remains with us today, the experts, the elite, who's running the government. And the council manager form of government was an innovation at the time to say, we're going to hire a specialized manager, credentialed, and he's going to run the city or town. The hybrid form that kept the old concept of an elected official exercising the executive power is the mayor-council form. And the council form, in a nutshell, is the form in which there is no designated executive office. Council controls all powers. My own instinct is that council form is most appropriate for governments that have relatively low complexity problems. Does that make sense? Because you don't want to be going to council every single time you have to do something. You want someone to be able to carry the executive power. Just as an interesting, again, I like the history. I've lived here my whole life, so I get interested in this stuff. But in addition to the 3 forms of government that you can choose from, they also said the legislature should create a provision for charter cities. That's why I told you about charter cities earlier. We had this idea that the General Assembly could allow you to basically secede from the state. I mean, secede is a strong word, but become a charter city, be independent from state control. But the General Assembly, that's the final bullet point on this slide, the General Assembly has never adopted this true home rule provision. So where we are, the history doesn't matter, because where we ended up is we have these 3 forms of government.
So Eric, can you hold for a second,
Yeah.
please? So we have the mayor-council form of government.
Yeah.
Can you go through and explain what the mayor can and and I'm not attacking, I'm just actually doing for all of this stuff.
No,
just-
that's the reason we're
yeah.
doing this,
So what-
because there is often question, there's often a lack of clarity.
Yeah, so that's what I'm
about
looking for.
What
What-
the relevant responsibilities are.
Exactly, so that's what I was going, what
Yeah, and I
does the
have
mayor
slides
do?
on that. We're
That's coming.
going to go specifically through the mayor-council form of government.
All right, thanks.
We're at overview point now. I wanted you to know what the 3 forms are, and we're going to go through slides. I will caution you in advance, and Mayor Belt has been through this with me before, there are a lot of questions in South Carolina we don't know the answer to. And the reason we don't know the answer to it is part of why I gave you all this history, is that as much as I love my home state, we're a little bit behind the rest of the country. And a lot of these questions, so we don't have a lot of reported decisions on these questions. We don't have a history of a lot of litigation in South Carolina over these kinds of issues. And the reason is because we were kind of a sleepy little state for most of history. But we will get into particular slides and we'll talk about those issues.
Thank you, Eric.
So what distinguishes the form of governments? I've kind of already said this, but the major difference is where the executive powers are. You know, who has those? The legislative function is always with council. And if you think about it from from a corporate context, if you've worked in the corporate world and you think about intuitively, what does the board of directors do compared to what the CEO does? The board of directors sets policy, they do strategy, they do vision. Where do we want to go? In military terms, you call that strategy, and you call what the executive does tactics. You know, but you got to figure out who has that executive or administrative power. So the performance of these executive administrative functions pursuant to state law is what differs between the forms. So here we are. We're in, I like this slide because this helps you get a sense. We have 271 municipalities. People are always shocked when they see how small our cities and towns are. But of our 271, 124 of them have less than 1,000 people. So, you know, basically almost half of them are less than 1,000 people. 209 are less than 5,000, and of the 271, 233 of them are less than 10,000 people. So when I tell you we've been kind of a sleepy state, we're growing a lot now, and you know, there's challenges that come with that. But you know, when you look at the state, we don't have very many big cities. These kind of issues that we're going to talk about have just not been high priority. Mayor council form is 137. It's the most common form of government in South Carolina. The reason it's the most common, I think, is because it makes, in a lot of ways, the most intuitive sense. The mayor is the executive or administrative officer. Just intuitively, it makes the most sense. Council form is 100. You'll see that only 3 of those council forms are over 25,000. You know, so, and council manager, there's only 34 council manager cities. There's, I mean, because I used to work for the city of Sumter, one of my interim stops, I like to tell this, city of Sumter was the first council manager form of government in the United States. We pioneered that form. It was dreamed up by the progressive local government intellectuals, and Sumter was the first one. But that's how it breaks down. I always expect that you'll see more of a break between the population densities. I would have expected, for example, council manager 34, that would be the most common in the largest cities. And I guess it is. We have 10 of those over 25,000. So if you look at the 16 cities over 25,000, over half of them are council manager. The other split, but that's the way it breaks out. There are ways of changing your form of government, and some of these cities that are growing a lot now, like Somerville is a good example of a town, and I'm not proposing that they're considering changing their form of government, but when you look at North Charleston or Somerville, these were traditionally kind of small places, and they're really growing a lot now as people move here. So we have this conversation as your challenges evolve, as you become, as the issues you're facing are more complex. Somerville's, like, you know, running Somerville is different now than it was 20 years ago. And so they consider changing their form of government. So let's talk about the mayor council form. That's all by way of introduction. Yes.
Before you leave that, what would be the things that would drive Somerville to change? I mean, you said, is it just complexities, or is
well,
it?
well, first off, it's largely driven by growth. I mean, you know, most municipal difficulties are driven by changes in population, either because you're dying and you're trying to save the city or town because people are moving away, or more likely in South Carolina because people are moving there. And when people move there, developers want to build homes. People need roads, traffic gets bad. People who have been there before want to stop the growth. I mean, I know we're being live streamed, and I'll be careful to describe this, but like when you look at a town like Mount Pleasant, you can almost predict the outcome in elections in Mount Pleasant based on what's the development environment. You know, there's people, like somebody will run saying Mount Pleasant is growing too fast, we need to slow down the growth, they'll want to adopt rigid land use controls, et cetera. They get elected, and then there'll be a period of time where growth will become frustrated, and then the next election will be, we need to reopen the floodgates for development because the developers are mad. And so you turn these things over. So, and I'm not taking a side in that, it just creates these tensions as you grow. Your services become strained when you grow. You know, does your police department get bigger? Maybe you don't have a police department, you need to add a police department. You've got to raise money for the fire departments, because to maintain your ISO ratings, you need to have fire departments every so many square miles. It's just a much harder endeavor to run a big, densely populated city than it is, let me try to think of a good example, like.
So you take it away from the mayor and you distribute it across the council and make council members responsible for different things, or?
No, you can't really do that. We don't really have this, well, that's a whole, in terms of funding, you can't do that. You can't allocate it.
I'm just
based
still
on-
trying to get to why the change to, what's the?
What you would find, what the textbook would say is, as you grow, as your questions become more complicated, the council form of government becomes more difficult, and you would want to move to a single person who's in charge of the executive and administrative functions. And that may be council manager, it may be mayor council.
Okay.
But it becomes, if you think about it, like, we have cities and towns that have almost no business at their monthly meetings. They come to their monthly meetings and say, here's the budget report, or here's the audit. And then we have cities and towns that have 6-page agendas for every meeting. We have all these development projects, we have all these service issues. And as the demands on you become more intense as a resource provider and a regulator, it becomes more efficient to concentrate the executive or administrative power into a single person with a staff.
Thank you.
That make sense?
Yes.
Everybody follow that? Okay. So in the mayor council form, these are just bullet points. We can talk about any one of them, and these are summary bullet points. We've assembled the law. In the mayor council form, the council serves as the legislative body. You always have the legislative power. The council does, kind of no matter what. And you make policy. You set visions for the town. You answer legislative questions. You have the power to approve the annual budget, which must be balanced. That's a whole nother topic, but you elect the mayor pro tem. The majority may call special meetings. So, what state law says is that you meet at least once a month for regular meetings. You have an agenda for those regular meetings. But then you can have special meetings on the call of either a majority of council or the mayor. So the majority may call special meetings, and there's certain staff positions that by law you appoint. You appoint the town attorney, you appoint the town judge, and you appoint the town clerk. Those are kind of the special positions that belong to council as kind of a personnel agency. Going along with the appointment power is the removal suspension power, so that for those positions, they cannot be hired without a council vote, they cannot be fired or suspended without a council vote, for those positions.
I have a question
Yes.
about monthly meetings. What if one of them has to be canceled?
There's not an answer to that. What state law says is, well, I think there is an answer, but it's a practical answer rather than a legal answer. State law says you have to meet at least once a month. It provides no remedy for failure to meet once a month. So if you cancel a meeting, you have technically violated the law by not having that meeting, but there would be no real ability for anyone to enforce that. And I'll tell you, it happens all the time, especially for our small towns. They miss a meeting. The only remedy would be that someone could sue you and ask for a declaratory judgment, an injunction requiring you to meet. There's not a penalty, there's no fine, there's no invalidation of acts. It's one of these, state law says you're supposed to do it. If you don't, there's really no legal recourse for a person other than to force you to meet. The only time I've ever seen it become an issue, Mayor Belt, just a quick thought on that, is if a council routinely fails to meet. I have seen cases where citizens say, we have a ghost council, they don't do a damn thing, and then they'll go to court or they'll file a complaint and say, you got to meet. But that's the only time I've ever seen it. If you miss one meeting, I wouldn't worry about it.
Well, and Madeline raised the issue because we canceled our August meeting because of Debbie.
Yeah.
And but interesting things, had been thinking about that. There is no, it says once a month. It doesn't say, the statute doesn't say calendar month or every 4 weeks.
Yeah.
It's one of those issues where there isn't real clarity, and it wasn't clear whether it had to be a regular meeting and or a special meeting, because we actually did have a special call meeting just before that, a couple of days before that. So we did meet as a body, kind of within the same kind of time frame, but there was a month when we did not have a regular agenda meeting, and it was due to Debbie. We just rolled everything over into this September
Well,
meeting.
and if you wanted to trace it back, Mayor and Council, the way this meeting once a month is implemented is through the Freedom of Information Act. And it says at the beginning of the year, you publish a calendar of your regular meetings for the whole 12 months. So, and that's what drives that, is at the start of the year, you say, we're going to have a meeting in August. And then, and those are, I always wonder how deep to get into these questions, because as you've gathered, I mean, I find this stuff interesting, I hope you do too, but the conceptual idea here is Congress and the General Assembly have sessions. And so the public knows that the General Assembly is going to be convened in Columbia from January to May. And they know that Congress is going to be in session, you know, they have a regular session. City and town councils don't have that. So what state law says is the way you have your sessions, the way that the public knows when you'll be doing your general business, right, your session, is based on your annual calendar. So you publish your annual calendar. And then the way they implement that is they say, meet once a month, publish your schedule in advance. If it comes to August and you have Debbie and you have to miss the meeting, there's nothing's, that is fine. It happens all the time. Does that make sense? And someone could say you committed a technical violation by not meeting in the month of August. If you're meeting regularly and you've published your annual agenda, the court's just going to throw that case out and say, Debbie came through, what were you going to do? You can't force people to meet, right? And then you'll just move that business either to the next regular meeting or, Mayor, as you said, to a special meeting. And that's typically what we advise, but I can tell you, when Debbie came through, when COVID happened, I was having weekly calls and saying, you know, from somebody, you don't have to meet this month. It's fine, right? So that's council powers. There's kind of an interesting ambiguity in the statute, but the statute says the mayor and council may appoint an administrator to assist the mayor. The language that's ambiguous is it says the mayor and council may appoint the administrator. There's a fairly recent attorney general opinion where someone said that gives the mayor the veto power over the administrator. And the attorney general said, no, those aren't separate appointments. It just means that the council, including the mayor as a member, appoints the administrator. But it does say to assist the mayor. And why does it say to assist the mayor? Is because council-mayor form of government, the mayor is the chief administrative officer of the town. And so the administrator, as a personnel matter, is appointed to assist the mayor. There's no cases really testing, like, you know, what does that mean? But that's what the statute says. Council may establish departments. So if you wanted, for example, to establish a police department, to establish a fire department, to establish a codes enforcement department, then that would be a council power. And you can prescribe the functions of those departments. This has occasionally been a really critical power, as you may investigate departments. I've had a few cities and towns where council says, well, we've become concerned about this department. Either the manager or the mayor has said, that's under my bailiwick, I'll do that. And council has said, no, we have a separate power. And if you think about it, like if you're a news person, Congress has this power too. Congress will launch investigations into, you know, or into departments of the federal government. They have the power to subpoena. You have that power to do those investigations. You can establish personnel policies. There's no law on what that means. Like you can establish personnel policies. Like when you test that out, there's no law on you know, how detailed the personnel policies can be, exactly what that means. But what the law literally says is you can establish personnel policies, and then this residual, all other power is not provided for by law.
Excuse me, Eric.
Yeah.
Can you go back one slide, please?
Sure, yeah.
All right, so on this particular slide, you show that in the first bullet, the council may appoint an administrator. If you go back one more slide, please. The last bullet states the council can appoint a clerk. I'm just curious, Stephanie here, is she, according to these bullets, a clerk? Or is she an administrator, assistant? What would she be?
She's the administrator, right?
She's the administrator.
Do you have a separate clerk position? You probably do, right?
Okay, all right. So, all right, so I was waiting because I wanted to make sure before we went too far into this. So Stephanie's role has not been identified yet on these two slides.
She's
where
the
is she then?
administrator. When she, under this state law provision that she works under would be the administrator position. May appoint an administrator to assist the mayor. To give context, in the council form of government, you can appoint an administrator as well. In both of those, the council form of government and the mayor council form of government, the administrator, the title is used administrator. That appointment power belongs to the council, but the difference is the administrator, well, let me say it this way. The administrator in both of those models has the powers that council has given him or her. Does that make sense? State law doesn't
Yes.
specify any.
No, it does. I just wanted to understand how Stephanie's role was defined, and so it's as an administrator. That's,
She's, under state law, her state law title is town administrator.
that's what I was looking for, okay.
Yeah.
And the statutory responsibility is to assist the mayor.
That's what it says in the statute.
Yeah.
And again, I know there's probably some sensitivity on this point. There are no cases or AG opinions saying how that works. There's never been a reported case in which council says, this fight has happened over, what's the difference between the administrator in the council form of government and the mayor council form of government? In other words, what is the specific meaning of that assist the mayor? That's never been litigated.
Okay.
What has been established is that in both the council form and the mayor council form, the administrator is hired by council and suspended or terminated by council. So council has the ultimate control over the administrator. And where we're going to end up with all this, that you're going to think it took us an hour to get here. What I'm going to say is at the end of the day, all of these questions can be resolved by council, but you have to agree to how to do it. And I'm going to give you some examples of how you could do it.
Go ahead, Matt.
So,
I'm sorry, so that means, so Petra's the clerk, so she's appointed?
The clerk is appointed, and the clerk, so the
Appointed.
clerk, unlike the administrator in your form of government, the clerk has specific statutory duties. The clerk keeps minutes of the meetings, he or she is charged with keeping the ordinance book. There's certain statutorily defined functions of the municipal clerk, and you have to have a municipal clerk who has these powers. The administrator,
And by the way, that's exactly true with the road as well. The town treasurer, it also is a statutory position with statutory responsibilities.
yeah,
Okay, so
less
because
so, and you can combine those roles, but yes, that's right.
All right, so I'm just trying to understand all this, because I've been here now 2 years, and I don't recall us reappointing. Is this something you have to do every year? No, it is
No,
not.
they're
Bas-
considered to have an office.
I believe, and I'm just going off memory, based on our ordinance, the town attorney, the clerk, and the planning director are reappointed after every general election. So our next general election, which would be next year, not this one, I believe, because this won't be a special election. Next year, if that's our general election, that's when those three positions will be
Okay, so,
reappointed. But I have to go back on our ordinance. I think our ordinance is general election. I don't think it makes reference to
And
special
that's why I'm
election.
trying to understand the timing of that, because I may not remember, but when I was elected, that was a general election.
And I
I
think
don't
we had-
remember appointing
I think
any.
we had them, we put that on typically on the January agenda, along with all the appointments. As you guys may recall, you have a lot of different appointments.
Yes.
And those are included when the time comes up those positions are
Okay.
also included.
So it's after every general election?
I believe, and I think the mayor is looking that up, but I thought it said every general
Yeah,
election.
the term of office for the appointed town officers shall be at the pleasure of council, but then on the other hand, we say in the subsequent provisions with regard to the clerk, the town attorney, and town treasurer, at the first regular meeting of council following the inauguration meeting, the council shall appoint such officer.
All right, so that means this coming January will be,
We could, when that was written, it was very clear and easy because we used to have elections every 2 years. So the inauguration was typically every 2 years, and that's when those positions came up. Because we've had essentially we'll have 3 special elections within a 12-month period, we have not put those positions up because that's just one person being sworn in. So we've typically followed the general election. So next year, when the general election comes up and the inauguration for those positions, we've done it, but that's just something that we probably have to look into with our town attorney in terms of that language of the ordinance.
okay. I
Even,
understand.
so.
I'm just trying to understand the way it's supposed to work and now I know you're an administrator.
Yeah, and I am not, and I guess when they said me appoint, how I'm set up is I have a contract, so I have not been officially put on the agenda to appoint, but you guys effectively, when you approve to renew my contract, maybe that's a form of appointment, I don't know.
Yeah, and so I don't know historically why it happened in Kiowa Island that your local code says that. But I'm going to give you 2 state law concepts that I think those could be responsive to. One is under state law, when you appoint someone to an office, they serve until their successor is qualified, appointed and qualified. And so someone like the administrator, Stephanie's occupation of the role of administrator, that appointment is valid until any contrary action is taken. Does that make sense? Like, so she's appointed, that's the first language. The way that you say that in law is serves at the pleasure of council. And what that means is it's an indefinite term. Like when you're elected to council, you have a definite term. You have, a 2-year or 4-year term under state law. Someone who serves at the pleasure of council has an indefinite term. They will serve indefinitely, until you do something different. On the other hand, I would guess that the reason that the reappointment after the election is there is there's this concept in state law called binding future councils. And the idea is you're elected bodies and you as elected officials on the council cannot deprive the legislative freedom of your successors. You can't take away their legislative powers for future councils, right?
One exception.
Yeah, well, there are exceptions can be provided for by statute. For example, under the Development Agreement Act, which y'all are familiar with, but there are other exceptions, but they have to be provided by statute. And so there have been issues litigated, Stephanie, you say you have a contract, over if your administrator has a contract that was approved by a prior council, is that binding on the current council? And so there are good reasons why you would reappoint the administrator after an election because that removes the binding future councils.
So in that regard, Eric, one of the issues, we looked at this kind of as prior council, but I mean, you could see them coming up again. It says indefinite duration. And the way I've looked at that is, yes, it stays in the position until further action. But you could say at the outset, I think it's within council's prerogative to say appointed for 1 year.
Yeah, you could.
Yes. But even if you said appointed for 1 year, the council still appears to have the authority to change its mind and remove that person at any time.
That's right.
So if an administrator has signed a 3-year contract, then does that have to be somehow moved upon by council again every year, or should it be? What overrides it? The term
Whether
of
it
the
has to
contract?
be is a contested question. I'm going to tell the story. So the reason that we have this really weird law, we have this idea of binding future councils. Every municipal lawyer in South Carolina thought that what that meant was You couldn't bind the legislative powers of future councils, but you could bind them on business matters, proprietary matters. Our view, let's go back so that it's not personal to Kiowa Island. Let's look at my situation in the city of Sumter. I reported to the city manager. He was appointed for an indefinite term. He had a contract. His contract provided that if he was terminated, he was paid severance pay. He'd be paid a year's severance pay. My view is that's a proprietary function, and every lawyer in South Carolina thought that. They thought you can fire the city manager at any time, but if you do, it's going to cost you a year's severance pay. That's pure money. That's the way we all looked at that. And the reality of it is it is difficult to find a good manager or administrator. It is also difficult if you are a manager or administrator to find a new job if you lose yours, because there's only so many jobs as a manager or administrator. And so take my boss in Sumter, so it's not specific to Kiowa Island. When I was working for him, he's my age. At the time, he had 2 kids in high school. He owned a house in Sumter. And if they had terminated him, then he was going to have to move, because there's no other city manager job in Sumter. Does that make sense? He's got to move, he's got to take his kids out of school, and he's got to find one of the 8 or 10 jobs that are available as a city manager commensurate with his experience. And so my view is you don't recruit a good administrator or manager unless you offer them severance pay, because it's going to take them time to move their family, to sell their house. And it's not like a banker, where a banker can wake up tomorrow and have no offense to the bankers of the world, but I live in Charlotte, and bankers lose their jobs all the time, and then a week later they're at another bank in Charlotte. It's different if you're a manager or administrator. So it's very important to us at the Municipal Association. We want you to be able to pay severance pay. We want you to be able to have a contract, because that's how you recruit good people. And you're not going to get a good administrator unless you've got a good contract. That's the reality of the profession. What happened is bad facts make bad law. Y'all have heard that expression, bad facts make bad law. And what happened is we have a county that I will not name in South Carolina that had a county administrator. A slate of candidates ran to fire the county. Basically, one of their platforms was, if you elect us, we're going to fire the county administrator. They won the election, and in the time period between the election and the swearing-in date, the lame duck council terminated the administrator and paid him like $2 million in severance pay when you add it all up. And then they paid it. And so then it went to the Supreme Court, and the Supreme Court's going to say, well, we're not going to countenance this. This is bad behavior. And so they said in that case that severance pay was binding future councils. I think that's the wrong law, but it's what the law is. And so we spent a year after that case trying to figure out how we do the administrator contracts and manager contracts. I think there are ways they can be drafted to where they survive an election. Having said all that, because the law, in my opinion, is bad, my recommendation is you reappoint the administrator after every election, because this makes that question go away. But that's just my general 30,000-foot view on it.
So this first bullet point is news to me. In the event, hypothetically, that we had a vacancy for administrator, the council would be the body that would initiate the entire hiring practice?
That's an open question, too. I've got this question right now. I've got a mayor-council form of government in another place where the council is trying to hire an administrator and exclude the mayor from the interview process. And so I'm talking to them, I'm saying, well, the mayor gets to vote. Clearly, state law doesn't say how you run the interview process. That's not the kind of question that state law is going to answer. And so so I've told that council, I said, to me, it makes absolutely no sense. The mayor is a part of council. You shouldn't exclude that person from the interview process. The administrator is going to essentially report on a day-to-day basis to the mayor. Why would you not allow the mayor in the interview process? But, one thing we've learned in the modern era is that a lot of things are based on norms rather than based on laws. And, what can you do? Well, if there's no state law that says that the mayor, what role the mayor plays in interviewing the administrator. And the reason there's no law is partially because for there to be law, there has to be a litigated case that gets reported. But secondly, because norms, historically, you just wouldn't do that. You just wouldn't exclude, you wouldn't game the interview process. Everybody would try to do the best. I mean, You follow me?
Yes.
But you can, and again, I'm going to give one specific example when we get to how you structure these kind of questions locally, but there's not an answer to that.
But one thing that should be clear, Madeline, is in contrast to the clerk and the treasurer positions, essentially council is obligated to appoint those positions. Council is not obligated to appoint an administrator. We don't have to have an
Yeah,
administrator.
you may appoint an administrator. That's true in the council and the council mayor form. In the council manager form, you have to have a manager. You have to. In this form of government, you can have an administrator if you want one.
Is there an administrator for Charleston City? I don't know if there's a town administrator or not.
I don't think they have a person, Mac, do you know that? They don't have a
just-
person named the administrator, but they do have like a chief of staff.
It's
and-
chief of
They
staff,
do,
I
yeah,
guess.
it's Liz Deek, yeah.
Yeah.
But that person is actually appointed by the mayor, hired by the mayor, I believe, not appointed by the council.
Yeah, I'm not sure how,
I don't know the details of that. Ross would know.
I think that's what he said. I think that's what he said.
yeah, Ross would know, and have a very close relationship with the Charleston Legal Department. I can find this out.
Yeah, I mean, it could easily call Julia Court.
Yeah.
So going back to your example where they were trying to exclude the mayor from the interview process, let's assume that the council appointed administrator that the mayor didn't like or didn't want. And then the next bullet says the council prescribes functions. So if the council gave the administrator full authority to do X, Y, and Z, the mayor couldn't sideline and say, I don't give you that authority, right?
Legally, no. Practically, yes. I mean, so much of this is practical common sense type stuff.
So Eric, I'm going to push back because this is one of those kind of questions that I've looked for to better understand, the give and take, and there isn't any guidance. The council does not have the authority to take away the mayor's statutory responsibility.
Yeah, we'll talk about that in a minute when we
Okay.
get to the mayor's powers.
Yeah, so the council can't alter that. For example, the council could not appoint an administrator and say, you are the chief administrative officer of the town, as an example. Because state statute provides that the mayor is the chief administrative officer of the town.
Yes, but we'll talk about mayor. I agree with your point. On the other hand, state law doesn't say what it means to be the chief administrative
Exactly,
officer.
and that's what I would, I've been asking around, is there any guidance out there? And there appears to be none.
Not in South Carolina.
Yeah.
No, I've looked at this question under other state laws, and, I mean, here's one thing you need to think about too, though, is that, I've said multiple times, there's no reported decisions on this question. Part of that's because we're in South Carolina. But part of it is because these questions don't get litigated. I mean, who would have standing to assert that claim? It's an internal dispute. Like, let me take an example that we're going to talk about in a minute. Let's say that in your form of government, the mayor council form of government, the mayor goes off and signs a contract without approval of council. And let's just assume that everybody knows that the mayor needed approval of council to sign this particular contract. That contract is probably going to be binding because the mayor is going to have apparent authority. The counterparty to that contract is going to say, well, how was I supposed to know that the mayor didn't have the authority to sign this contract? I didn't know. So this is just basic agency law. And so it's really, all these questions end up to an internal personnel question. And those typically don't get litigated. They typically get resolved by elections or internal discussions. And one of the hardest parts, and I'm not, again, I want to emphasize repeatedly, I never make partisan political points. This is across all points, is that one of the things about the time we live in is those, what the law has historically expected you to do is you work this stuff out. And the era we live in, I'm not saying this anything about Kiowa Island Council, but when I'm dealing with my other members, in the political environment we live in, people don't want to work things out internally. But historically, that's the way things happen, is you work it out. And I'm going to give you an example, based on a question that Mayor Belk asked me earlier. And so much of running a successful city or town or a successful city government is people work together and figure out and say, here's how we're going to do this, rather than go to court. So.
You know, it's interesting. I found it fascinating that, as you said, there isn't much guidance in South Carolina law on this. I mean, to what extent should we look at models outside South Carolina? Because Washington D.C., where my prior home, I mean, or Philadelphia or New York, people pretty well understand what the role of the mayor is versus the role of the council. Now, you still may have tension, and I understand there's some of that tension occurring in Charleston right now, because the current mayor is you know, exercising authorities in a different way than the prior administration has done. But these aren't issues of first impression more broadly. They may be in South Carolina, but they're not generally.
Yeah. No, and I think that it's useful to look at models from other jurisdictions. When you're looking for, I mean, what I'm going to end up suggesting is that you actually put in writing how these questions are answered. And I set up one example that I'll hand out. And when you establish personnel policies, these questions you're asking me about the administrator position, those can be resolved by personnel policies. Who does the administrator report to? What are the administrator's responsibilities to council? If you were to go look at Philadelphia or Boston, they have rules on this. They've adopted these kind of questions because they're cutthroat politically, they're huge, and so they've had to resolve these questions, and they put it down in writing. And even in those states, though, it's unusual for those to end up in reported court decisions. What happens is you do the messy work amongst yourselves and figure these questions out. Any more questions?
Great, thank you.
Yeah.
This is really great.
So the mayor's powers, these are statutory granted powers. Mayor Belk has already mentioned these cannot, according to the AG, the Attorney General, these cannot be taken away. They cannot be varied by local law. So I'll give you an example, like presides over meetings. By statute in the mayor council form of government, the mayor presides over meetings. He's what you would call in parliamentary procedure, the chairman of the meeting. There have been attempts by cities and towns to have the mayor council form to take that away. And the Attorney General has said you cannot take that power away from the mayor and the mayor council form of government. You can in the council form and the council manager form. And I was involved in one of those disputes where we had a toxic mayor. I'm not in any way suggesting that's a confined issue, but the mayor was very difficult, and council said we want to take his powers. We don't want him presiding at meetings because when he does, everything devolves into chaos. And they were council form of government, went to the Attorney General, and they said, yeah, you're council form of government, you can do that. And then council manager, the same thing, preside over meetings. Call special meetings. I've already told you in the earlier slide, this is a dual power. Either a majority of council or the mayor can call a special meeting. It's one of the few places where either of you have the power to do that. There was a really interesting case, just to give you an idea of what does get litigated. There is a town in South Carolina where by ordinance, the mayor controlled the agenda. So by local ordinance, the mayor set the agenda. A majority of council kept saying to the mayor, I want this item put on the agenda. And he wouldn't put it on the agenda. So the majority of council said, well, he's effectively exercising a veto power over us. So they took that to court, and the court answered two questions. One, could the mayor do that? And the answer was yes, because your local ordinance says the mayor controls the agenda. But if you really want to get this item on the agenda, what you do is you call a special meeting. A majority of council calls a special meeting for the purposes of that item. That's the way they resolve that. And that's how we know that's a dual power because of that case. Designates the temporary judge. That's as if you have a vacancy in the municipal judge office. This is kind of a residual power. Then the mayor has the authority to designate a temporary judge. Here's where all the action is, of course, and we'll try to unpack this in a minute. But it literally says in the state law that the mayor acts as the chief administrative officer without giving us any further guidance on what that means. Critical power, the mayor appoints and removes employees subject to personnel rules adopted by council. You'll gather that the exception to that, from what I've told you earlier, is the clerk, the judge, the attorney, and the administrator. Those positions belong to council.
To council or to the mayor?
Those four positions,
but
those
these-
four, but
everybody-
everyone else
Is it the mayor's?
is the mayor.
So it's not the administrator, it's the mayor's hiring and firing of the employees.
You could, in theory, delegate those powers to the administrator.
Okay,
But
do it in writing.
the mayor would fight back and say, what you've already said is that you can't do that because I'm the chief administrative officer by statute. And I don't know the answer to that question.
And what
Yeah,
are those?
I would probably be in a position arguing, just in a sense, from an institutional standpoint, that only the mayor can delegate that function. That the council can't delegate that function because of the statutory language, but.
I'm trying to navigate this, but what I can tell you is I don't know the answer to that. I can see the arguments on both sides because I think there's an ambiguity between those two statutes in the code. And I don't know if we could go back to 1975 and figure out when they were drafting this, why they structured it that way. I will tell you, I think the best structure is you don't try to delegate that power because it just creates problems.
What were the four positions? Clerk, judge?
Clerk, judge, attorney, administrator.
Stephanie mentioned town planner before.
It did come-
Treasurer.
Treasurer, okay.
Yeah, you guys appoint, based
you
on
said
our
planner,
ordinance.
but okay,
Yeah,
yeah.
based on our ordinance, you appoint the treasurer. The finance director is what we title it.
Yeah.
So, sorry, just to back up for me to be clear, the mayor can definitely remove employees other than the four.
Yeah.
And council can or cannot.
Under the state statutory powers, you cannot.
And the administrator cannot.
The mayor could potentially delegate that power to
Okay.
the administrator. And what I think, Mayor Belt, what you were asking is, could council delegate that power? And my answer to that is no, probably.
Okay, thank you.
But there are no, I don't think, there are attorney general opinions, there aren't really court cases. There are a bunch of attorney general positions that, as you alluded to earlier, that have addressed this issue of the statutory positions.
Cannot take the statutory powers away.
Yeah, and that the mayor does not have any unilateral authority to, even though they may be reporting to the mayor effectively on a day-to-day basis. And as a practical matter, the mayor still doesn't have the authority to remove those persons.
That's right.
Yeah.
Yeah, that's right.
Eric, when they talk about, you hear the term all the time, weak mayor form of government, strong mayor form, are they just referring to the mayor-council form versus the
Yes.
council form? That's essentially what that is?
Yeah, and also weak mayor would be council manager form. Strong mayor is mayor-council form, the weak mayor are the other two forms. We don't love that term,
Yeah, I
you know,
don't-
because we
it's not
don't
a good
want to call any of our members weak mayors.
It's not a good term.
But that's the common term, yeah. Now, I wonder if this is a good idea. I'm going to do it anyway. We have a very interesting dispute right now. So if the mayor has the ability to appoint a position under state law, and you cannot take that power away, let's say the police chief. Let's say because I know this is easy because you don't have a police department, but let's say that you, by ordinance, have created a police department, and under state law, the mayor has the power to appoint and terminate the police chief. We actually have this question right now. Mayor appoints a police chief, council objects to the appointment of that particular police chief. Mayor says, it's my job. And the attorney general would say, yes, by statute, you have the appointment power. So what did council do? Well, they say, well, the thing that we do is we approve the annual budget.
Control the purse.
And so we're just going to zero out the line item for the salary of the police chief. And if he'll work for free, then great, you can work for the mayor. I mean, and so I'm telling you this because, I mean, all these things can really go wrong if y'all don't get along. You have to solve these problems.
That is not an unusual situation at the federal level.
Oh, yeah. Oh, yeah.
Federal level, that kind of tension comes up routinely between the executive branch and legislative branch. Okay, we don't like what the executive branch is doing. We're not going to appropriate the monies
Right.
in order to exercise that function.
Right. Yeah. So we'll see how that turns out. We're desperately urging them, don't do that. It's going to be, anyway. You can't imagine how many of our conversations end up with, please work this out locally. Please work this out locally. So mayor has power to designate the temporary judge, act as chief administrative officer, appoints and removes employees, and supervises departments. And I've given you all the statutory sites for these. Most of these are in 5.9, Title 5, Chapter 9, which is the mayor council form of government. Some of them end up in other places, like the designating temporary judge is in the title that relates to the courts. So some of them are straight around. Mayor votes as a member of council. There's this weird expression, ensures the faithful execution of the laws. We don't know what that means. I mean, the president has a similar, what does it say, Mayor Belt, with your time in DC, it says, the Constitution says, he shall make sure that the laws are faithfully executed.
Yeah, something exactly like that.
The mayor, this is an interesting power. The mayor prepares and submits the budget and capital program to council. We sometimes have this fight in other types of jurisdictions, who has the authority to prepare the budget. Clearly, council in all forms of government has the authority to approve the budget, but you have this question of who prepares the budget. And that question comes up that similar question comes up in two cases: who prepares the agenda, who prepares the budget. The mayor council form of government is not clear on who prepares the budget. I'm sorry, the agenda. That's why that case that I was talking about, there was a local ordinance that says the mayor has control of the agenda. It does say who prepares the budget. Now, obviously, Mayor, that will be done by your staff, by the council staff. But that statutory responsibility belongs to the mayor. The mayor has the obligation to make an annual financial report to the public and council, and then report to council on operation of departments.
And by the way, that second to last bullet is coming up.
So you just said council's staff,
The town staff. And I'm not making a distinction for that purpose.
but I need you to, because I have not understood that staff is in any way under.
I should be more careful on how I say that. All of your employees are town staff. The town is a corporate body. Who has the power within that corporate body to appoint those people is what's answered by law. Council appoints the 4 employees, mayor appoints the rest. They're all town employees, and that's what I meant to say instead of council's employees, town's employees.
Thank you.
And Madeline, it gets, by statute, the mayor is responsible for hiring and firing the employees, but for those for supervising departments. But the council is responsible for establishing departments and can conduct investigations if they don't like how the mayor is supervising those departments.
And also, I would add to that, although it's vaguely described, to establish personnel policies.
So Eric, if you could just pause for a moment, please. So I am really not suggesting to add this to our council meetings because they'll get even longer. But the last bullet talks about the mayor is to report to the council on operations of the departments. And again, I'm not suggesting we add that to our meetings, but we have not been doing that.
Well, yes and no. I will often, in my update, will talk about some of the things we've discussed in senior staff meetings. And then effectively, when Stephanie gives her report, she's doing that on behalf of the mayor and the administration.
Fair enough, okay.
But to your point, I've wondered whether, again, it's balancing how long we want our meetings.
Exactly.
Should we get a more detailed report from department heads? I would say in some instances, on certain questions or matters, that might make sense. But rather than having every single, reporting out from me or from Stephanie, what every single department has done since the last meeting would lead to particularly lengthy meetings.
Oh,
so
I know.
that's kind of, but I believe we are generally.
Yeah, and if I can add to that, so guys recall, this was under Mayor Labriola, we did that, I think, for a couple meetings where we actually had staff, the senior staff come up and they reported on their departments. The
Yes.
meetings were long. That somewhat ended. Then we went to, I asked them to then do in your agenda packets, you used to have a back tab that said general information, where I then just asked each department to do a write-up.
Yes.
That also went away. And so as the mayor said, what we do now is that I report out if there are certain things that I know that is of interest, or if any of you have asked questions. You may see at some meetings where I'll ask during the town administrator comment period, I'll ask the senior staff person to come up and speak directly.
Yes.
John Taylor was doing that a lot when we were talking about beach walker stuff. So that's an example of when he would come up and speak specifically on certain projects.
And when we have our senior staffings, that's just senior staff, those are 90 minutes to 2 hours, just going and reporting out kind of internally on that stuff. If we did all of that again.
I started saying, I'm not suggesting to do that, but.
But it's a fair point. It's kind of, is ultimately, how much information does the council want?
And I'll give an example. I mean, I worked for 7 years on staff in a council manager form of government, which I've talked about. And the manager has a similar responsibility as the mayor does. I mean, you can just think about the manager and the mayor as analogous positions between those two forms of government. And what we did in my former employer was, on every agenda, there was an item that said city manager's report. And the way he would discharge that is he would take a certain amount of time to tell highlights. Here's important things that are happening. And it wasn't a department by department. It was, we've just given development approval for this hotel. And he would go through the highlights. And then by design, you would rotate amongst department heads and say, this month, we're going to have a police department report. And the police chief would give a crime statistics report and enforcement. This month, we're going to have a planning department report. And the planning department would, and that would just rotate around. I'm not saying that's the way to do it, but that's what I'm familiar with. And in your form of government, you could have a mayor's report, and mayor, you could take an approach similar to that or different from that. Or you could have an administrative report and the mayor say, the administrator's making the report on my behalf. Totally fine.
We typically do both. So I definitely generally have a list of items that I'm providing an update to fellow council members and to the public, and the administrator will add on to that.
And again, this is one of those provisions of law that only, that only comes up when things are already off the tracks. Like, in other words, I've had situations where council says, the mayor's running the city or town completely by himself. He won't tell us what's going on. And doesn't he have an obligation to tell us what's going on under this? And the mayor says, I'm not going to do it. And so you get in these situations where, like I said, you're already dealing with what is essentially a personnel issue. They can't get along. And then you end up kind of fighting over these points of law. But what you see when things are working correctly is that you'll have a regular update. Here's the highlights of what's going on. And if you're interested in this department in particular, we can do it every meeting. We can do it once a year. Just what's council's pleasure. And we do see, this is not surprising. We see councils we have councils that have 10-minute meetings. The council members don't want to know anything. They're like, we show up, they're like a board of directors, get us out of here. And then we have councils that have 7-hour meetings because the council wants to know everything. So you really want to adapt this to your own character as a council.
Thank you.
And it depends on the complexity. I mean, I've had this conversation with Ross about City of Charleston. And that is obviously as many relatively complex issues as we're dealing with, 50,000 person city with, many other issues. He will say, we get reports maybe every 6 months on certain matters. It's just, as a council member.
Okay. Great, thanks.
I'm not sure, Eric, if you're going to discuss this, and maybe you are, not in the mayor's powers, but I know sometimes it comes up in terms of the role of the mayor pro tem.
The mayor pro tem simply acts as the mayor and has the powers of the mayor when the mayor is absent. And so, honestly, that really comes down to, in ordinary course, who presides at meetings, things like that. It's come up in a few cases where the mayor, if the mayor is out of town for one meeting, then all the mayor pro tem is going to do is preside at that meeting. There have been situations where the mayor is out for a sustained period, health reasons, other reasons. And in those cases, there's certain things that the mayor by state law has the right to do, and the mayor pro tem during the period of absence or disability is the mayor for those purposes. And the only time I've seen it in my 6 years at the association, the only time I've seen it really come to a head was during COVID, where, for example, if you have a local ordinance that says the mayor can declare a state of emergency and the mayor's out because the mayor has COVID, then the mayor pro tem is under the eyes of the law, the mayor, and so can declare the state of emergency in the absence or disability of the mayor.
So, but that.
But it's
raises an
one
interest-
sentence in the code, Mayor. Buck.
I
It's-
understand, but even there, the question is, what does that really mean? The fact that the mayor's quarantining, during COVID for a certain period of time doesn't mean he's not fully capable of exercising the emergency.
There's judgment associated. It says absence or disability.
Yeah.
Absence or disability. And almost always that's going to come up with presiding at a meeting. Mayor's out with COVID, who's going to preside at the meeting? This one case that I'm referring to, it was an elderly mayor who was, like in the hospital with COVID. So it was like, and they said, Mayor, do you want to act as mayor? No, I just like to tell stories, sorry. Because of my wife's job, I now live in North Carolina. I work virtually several days a week, but because I'm in North Carolina, I've been following this. I don't know if anybody's following Mark Robinson and Josh Stein, who are running for governor of North Carolina.
Hard to avoid, at least the last couple of days.
And this piece of trivia that I learned about Roy Cooper, the current governor of North Carolina, is that apparently, because the guys in my men's group at church were telling me this the other night, apparently under North Carolina law, when the governor is out of state, then the lieutenant governor has all the powers of the governor. It literally says out of state. So I was told, this is anecdotal, I've not read this in the paper, but by reputable sources was told that that's why, since Mark Robinson is the current lieutenant governor, Roy Cooper won't leave the state. And the only reason I'm telling you that is because if you had that clarity, if it said the mayor pro tem serves while the mayor is out of the state, then you have a clear answer. And because it's a funny story to tell, I think. But yeah, right. Yeah, that's right. So, but yeah, it just says absent or disability. I don't know that I've ever had a situation in which that issue really came to a head, though, about it being, what does it mean to be absent or disabled? So, this is going to open up. I've had people point this out to me before, so I have to address it. It's easy to say, well, the manager and the council manager and the mayor and the council mayor form of government have the same powers. But I wanted to show you in the manager form, and these laws are passed at the same time. The manager shall be the chief executive officer and head of the administrative branch. In the mayor form of government, the mayor shall be the chief administrative officer. And there is no case law, of course, distinguishing what the difference between chief administrative officer and chief executive officer is under state law. Does that distinction have a meaning? There is a rule of statutory interpretation when a court is trying to interpret a statute. The court will say if the General Assembly uses different words, we assume they did it on purpose. And so it must have a meaning. I have absolutely no insight under local government law what the difference between those two positions is. I understand, and those of you with a background in the corporate world can correct me because I'm not an expert here, but I understand in the corporate world that the difference between the CEO and the CAO, the chief administrative officer, is that typically the chief administrative officer is in control of internal affairs, whereas the CEO is a more outward-facing position, and that the CEO is expected to have some policy roles in terms of vision, strategy, whereas the CAO is not. If anybody wants to add to that in the kind of definitional meanings, but I think it's hard to import that distinction here because the city manager has no role in setting policy. The distinction there is that council sets policy, manager executes policy. So I don't know that would be the distinction here. I invite discussion or suggestions on what the difference might be.
I was part of the corporate world, and I've never heard of a chief administrative officer. There's COOs. and CEOs.
Yeah, and
those
I would
roles are
guess that those are
clearly-
probably analogous. We have a COO at the association, my understanding is that means you run internal things like IT, finance, HR. You
Again,
do those
it's more
things.
operational as opposed, it's more tactical as opposed to
Yep.
strategic.
So we did have a chief administrative officer, and it was exactly as you described. It was, the main two things were human resources and legal. And there was a time when IT was under it too. And that chief administrative officer would then report to the CEO. But it was, I think the big thing for us was legal reported up through the administrative channel, but ultimately to the CEO.
Yeah.
Yeah, and I've been in a corporate context, I agree, but there is a CEO that the chief CAO does report to.
Yes.
Yep. But, so absent that, Eric, I mean, I've looked at the language, yes, from a statutory construction standpoint, yes, there's supposed to be some, you assume that that the legislator was making some distinction.
Right.
But I've tried to look at the legislative history and, basic rule of statutory construction, but there's no evidence whatsoever that they actually evinced any particular intent one way or the other with regard to either of those.
Yeah. Well, so, we've said this already, council cannot vary the mayor's powers by local ordinance. Powers encompassed by CAO are not defined. And then, my recommendation for common or difficult questions, you adopt policies. And so I've given you, I didn't want to get anybody's hopes up, but I did bring, this is, I made 8 copies. I hope that's enough. This is, I'm not suggesting that you use this or that, I'm just saying, like, here's an example. There's 2 pages.
Thank you.
So one of the questions that Mayor Bell asked me on the telephone was how do you manage litigation? And so, like, this was, a fairly quick process. You're going to have lots of refinements to this. But I said, well, let me look at cities and towns or places that do have a litigation management policy. This could be a personnel policy, it could come under that, or it could just come under, a policy of how you want to adopt it. I drafted this up quickly. If there's typos in it, forgive me. But essentially what we're doing here is just saying, like, here's how we handle litigation. I've done it in 2 pages. And it basically says the mayor can file interim pleadings, reports to council, council approves the initiation of litigation, the settlement of litigation. I am not in any way taking sides on how you should do it, but I'm giving you an example of how it could be done. And I think that what you'll want to do, Mayor, for those kind of questions, I could have just as well done a contract negotiation policy. I could have done anything else. I just chose litigation management because you'd asked me about the interim pleadings. And I can tell you that state law has no guidance on if your lawyer says, I want to file a motion for summary judgment in this case, and the mayor says, fine, I approve it, and it gets filed, that question's not going to be answered. And so, and the only person who would be aggrieved, I think, is internally. The council would feel like I wanted to see that motion before it was filed. And so I'm just going to say the point I've made over and over again, the best way to address these things is to sit down in a moment of calm when it's a hypothetical and say, how should this be done?
This is extraordinarily helpful, and we appreciate this, Eric. And what you've put here, just skimming over it, is consistent. It puts on paper what is, I think, what you described, and when I reached out to, our town attorney and Ross, Julia Coronado, and a couple of other people, is consistent with what happens de facto in most other circumstances. But this provides some clarity around that, so, you have it on paper. And we can certainly consider doing this or something similar to this if the council is so inclined.
Yeah.
So Eric, pause for a second. So subparagraph C references authority over interim pleadings, and that the mayor is authorized to manage and approve those such pleadings. I don't have a problem with that authorization in this council, given that Brad is an attorney. But if somebody not experienced with litigation was in that mayoral seat, so that person may not really be up to speed in what can be properly done in these pleadings. What would happen then?
First off, you can always adapt your policies, and like, you can talk about this, but when I offer an example document like this, one of the questions I get is, well, how do we approve it? And you could approve it by ordinance. You could put it in your code of ordinances. You could do it by a council, adopted personnel policy. You could do it in any level of. My recommendation is that you do these less formally than an ordinance. You put them in basically council-approved policies, and you can have a mechanism to do that. That allows you on a single vote to change it. And so first point is, you can respond to your conditions. If you have a mayor who you have confidence in to manage litigation, then you could have it one way and then change it when you get a new mayor. The other answer to
You
that.
can change it with each mayor?
What's that? You could. Council could change the policy.
I
anytime
guess
you-
that's true. I guess we could, yeah,
Vote,
sure.
you can't bind future councils,
Yeah,
so
yeah.
council.
Yeah, and that's why I
doesn't
recommend-
have to go through the statutory process of 2 readings
Sure.
and.
Yeah, that's why I recommend it be done by policy. The other response to that is, the assumption is that your litigation is being run by designated counsel. Either the town attorney, if the town attorney is handling the litigation, or your other counsel. So the legal expertise is going to come by the retained attorney. And you can specify the retained attorney's obligations as well. There's an example in here. I've given some, and Mac, I should have run this by you before, but I was just throwing things down on paper. I've given some roles for the town attorney here, like the town attorney will report on litigation to council. The town attorney will do these things. You may not want to specify those because generally, that language might make more sense when you have an on-staff attorney. Like when I'm dealing with the city of Charleston or the city of Columbia that have on-staff attorneys. They're handling litigation, they're handling administrative appeals, they're doing all that internally. You probably, Mac, you have a defined scope of responsibilities. And then if you have additional engagements like litigation or an administrative appeal, you may use Mac or you may use someone else. So you want to give some thought to that when you're defining these roles. Like you may say instead of the town attorney shall, it may say the designated attorney shall, and then you have a defined term for designated attorney. But again, I don't know that I wanted, it's up to council, of course, if you want to go through this now and talk about it. But I just wanted to give you an example of what it might look like.
Sure.
And either Mac or me, this is part of my job, is helping people come up with kind of standard documents. And I'm happy to, I'm plugged in with the North Carolina and Georgia leagues. I'm a member of the National Municipal Lawyers Association. If you say, we want really good examples of a contract negotiation policy or whatever, we can pull those and help and get them drafted with input from you. I just wanted to show you what it would look like.
Yes, that's great, thanks.
Thank you.
And municipalities handle it. Some of them have set policies for every case. Some of them change their policy. If it's a very important case, they will ask that council be updated on interim motions and that sort of thing. And then some just hire the lawyers to initiate the case and they come back to propose a settlement at the end. And council, just depending on the nature of the case and the involvement that council wants. To this council's credit, they are very involved and do like sort of regular updates, copies of motions, things like that before we file with, at least with the current litigation that we have.
I noticed that your next slide is moving into
Different topic.
behind the gate. Would you guys like a quick break?
Well, I have I was waiting for him to get to the question, still more of what the mayor can and cannot do. So the mayor, I don't know if our ordinances define it better, but you must have a limit to how much, how high a value of a contract is that you can approve or execute by yourself?
Well, that is, we have ordinances that set forth in our purchasing requisition, that in fact, our purchasing ordinance is kind of a mess. We've had a draft provided by Mac's firm. I haven't spent a lot of time with that draft. It's it's complex itself.
All right,
that
so-
process,
all right, so-
but yes, all of that is ultimately spelled out. But there's, I think this is a good question to have, Eric and Mac, is the ability of the mayor to enter into a contract or delegate the town administrator to enter into a contract. Is that inherent authority within managing the affairs of the town? And particularly if it doesn't have, you know, if it falls within a dollar amount, under a dollar amount,
Right.
that doesn't require council approval, or does council have to approve every single contract that that a mayor or the town enters into?
Right, because where I was ultimately going with that initial setup question, if you will, is what's the checks and balance to prevent, Brad, I trust Brad, it's not the point, so he doesn't put his brother on the payroll. I mean, where's the checks and balances for that?
Well, that's a separate, ethics policy with regard to nepotism, but,
Well,
yeah,
but so,
yes, yeah.
your neighbor then,
Yeah.
so who,
Yeah.
where's the checks and balances if in the strong, forgive the term, strong mayor government?
I mean, with certain exceptions, those limits are drawn up by you. I mean, I would guess, I don't know, I'm not familiar with the South Carolina authority on this, but I would guess in the absence of any direction that the mayor cannot unilaterally sign a contract on behalf of a town regardless of amount. That's what I would guess.
So I was
Now,
waiting to
I wanna
ask
make the
this
point,
because
though.
you
I wanna
mentioned
make the
earlier
point.
he could.
What's that?
You mentioned earlier today that he could, and that's why I
Well-
was waiting for this question.
All right, so let me tell you why this question doesn't come up is because you should have a purchasing ordinance, and the purchasing ordinance should delegate those powers. And,
But the purchasing ordinance is with regard to the obligation of funds. Sometimes there are certain kinds of contracts or agreements that don't require, that don't involve different forms of consideration than financial consideration.
so let me tell you, how many of you are lawyers? Is Mayor Brett the only one, or is there?
And I'm not really a lawyer.
No, okay, so the question of, without any further adornment at all you have is state law. The mayor comes to you and says, I signed a non-financial contract. I signed a contract that, you know, that agrees that person X can use this facility. I don't know. What's an example that doesn't involve any obligation of town funds? So it's not a budgetary question, it is simply a contract. Did the mayor have the authority to do that? The way that question is going to be resolved is under agency law. An agency law says an agent can bind the principal. In this case, the mayor would be the agent, the town would be the principal. When can the agent bind the principal? And the question is going to be if he has actual authority. In this case, the mayor would not have actual authority because state law doesn't say anything about that. Does the mayor have implied authority? And the mayor say, well, I have implied authority because this is the way we've done things in the past. Council has always consented to it. It makes sense that it's part of being the chief administrative officer that I can enter into minor agreements without council approval. And then it's going to say apparent authority. And the apparent authority question is, notwithstanding of whether you had the actual or implied authority, express or implied authority, did the counterparty think that you had authority? And so then you'd say, well, the person who the mayor signed the contract with thought the contract was valid, so the contract's valid. It's not important to understand those nuances. What's important is every question is going to turn on the facts of the case when you get to the court, because agency is a common law doctrine. And so what's the point of that? You should be clear. You should clarify that stuff. And the way the purchasing ordinances work, and I don't know, Mac, did you work on the purchasing ordinance?
Nick Nicholson drafted it.
Okay, so we have a model, we call it the model procurement ordinance that Nick helped us draft, that I've revised over the years, that we can offer. I'll bet anything that it looks a lot like what Nick and Mac did. Nick Nicholson is Mac's partner, who's a procurement and construction lawyer, very good lawyer and a good friend of mine. And we've worked on this. And one of the key insights that people need to understand is when you see a procurement ordinance, it's really doing two things. One is it's saying when we're going to award a contract, what competition is required. Do we have to do a request for proposals? Do we have to do an invitation for bids? You know, how does how does a contract get awarded to vendor A instead of vendor B? How do we compete them? But the other thing a good procurement ordinance says is who has the authority to sign contracts on behalf of the city or town? When I was in my former employer, our contract said up to, I think it was up to $10,000. So if it had no value or up to $10,000, then the purchasing director can sign it. If it's 10 to 25, then the finance director. If it's up to 100, then the city manager. If it's more than 100, then council. You can make up whatever numbers you want. You can make up whatever staff positions you want, but you put clearly down, contracts with no value or values up to X, Stephanie can sign. Contracts with value up to Y, mayor can sign or however. But it's so low effort to clarify that kind of issue that I think you should. And I got to be honest, in preparing for this meeting, I did not have time, as I ordinarily would have done, and I apologize for that, to review your own code. So I don't know what the Kiowa Island Code says about purchasing now. But I'm just going to tell you, answer the question, just put it down on paper.
All right, so you're doing a great job with all these answers. So I just have a question for Stephanie and/or Brad. In an emergency situation, of course, the mayor should have the authority to execute a contract for that, to address that emergency issue. What is the limit in that situation? Or is there a limit?
The limit is 250,000.
250 in an emergency? Okay.
That's correct.
And I think I have a credit card to be able to incur some of those expenses, but I think that is 50,000 on the credit
Okay.
card. But so Eric, the contract, I mean, these are actually a lot of real world kind of issues. There's not a lack of clarity, but for example, contract, you mentioned the point about appropriating funds. Again, hypothetically, I wanted to hire somebody to do something and they would work for free. And so I will enter into an employment contract with them without any compensation. Does the mayor have the authority to do that or not?
I would think yes, but I would put a nuance on there. It depends on what potential obligations could arise under the contract.
But I think where this issue.
In other words, like, is there any potential that monetary obligations would be triggered? But if not, then I think that's an administrative officer question.
So where is a practical day-to-day matter where a lot of this, relative, who has responsibility for what comes up, is in the administration and enforcement of ordinances. And we talked a little bit about, an easy example. We have a lot of our ordinances, for better or for worse, that simply say, somebody has to get permission or approval from the town to be able to do something. And that's all the ordinance says. My reading of that is the council's established the policy. It's a pretty broad policy. The administrative branch then has the authority to set the conditions of that approval. As long as they're reasonable and rational, they have the administrative branch have the authority and discretion. Now, alternatively, the legislative branch, us collectively, could specify all the conditions of approval in the ordinance itself. But absent doing that, it's a general enabling statute, and then it's up to the mayor and the administrative branch to actually determine what are the policies and procedures under which that approval is granted. Fireworks. The town could simply have an ordinance that says no fireworks on Kiowa Island. It could say an ordinance, no fireworks allowed except on these days, at these times, and with all of these other approvals. Or it could have an ordinance that says no fireworks unless approved by the town. And if just the latter one, then it seems to me that it's incumbent upon the mayor and the administrative, the legislative, the executive branch to fill out the details and establish the policies and procedures, and it has the authority to do so.
To me, the word, I mean, well, I think in an ideal world, instead of using the word town throughout y'all's ordinances, it would be better if it said town council or city council or mayor, like explained who exactly.
Or a staff person.
Or the administrator, or whoever, yeah. So, I mean, that, because town is, in my opinion, is somewhat vague. It leaves open, is it town council? Is it the mayor? Is it town staff? Like, the town is all of those things.
Yeah.
Okay.
Yeah, and so where you see this is in zoning ordinances where it's like, a person needs a certificate of zoning compliance. Who has the authority to issue that? You need a special exception to the zoning ordinance to develop this. Who has authority to do this? And very often, like the best example I can think of just off the top of my head is like a parade permit. Like if you're a city that has event or parade permits, your parade or permit ordinance should say the police chief has to approve it, or whoever, based on, what's the issue involved. I mean, Mayor Belt, I would tend to agree with you that if the statute is silent, that the mayor could make that decision. I would caution, this is another reason to have written, to put things down, and this is more work, but it saves time later, is that you have these constitutional issues associated with unfettered delegation. There are two constitutional issues. One is delegation of the legislative power. Like, can you delegate in the federal government, can you delegate to an administrative agency the authority to make law? And there's a lot of law on that. How much can you delegate? And so the question would be, in this, by analogy, can you delegate the authority to the mayor to make these determinations? The answer is probably yes, but it's helpful if you make it clear what the terms of the delegation are. The second constitutional issue is you're always going to get in constitutional trouble if you're trying to enforce a law that is subject to the arbitrary enforcement of an individual. That if the ordinance simply says no fireworks on the beach unless permitted by the town, and it says nothing more, and the mayor is administering that policy and giving permissions, and he has no written standards for how that determination is made, then that is constitutionally infirm on due process grounds, because the person has no notice of what the conditions are to get it. So you want to put it in writing. You could either delegate to the mayor shall determine how this permit shall be issued by policy. I've drafted those. You just say, here's the elements to be considered. Or you can say, this is how it gets done.
So we have in my view, a dual set of problems or issues with regard to our ordinances. One reason we need to undertake a fairly broad review of ordinances is we do have a number of these ordinances that say exactly what Mac identified. It's simply permission of the town, and it's not clear what that is. In addition, with regard to those from an administrative function, in too many instances, we don't actually have written policies and procedures that provide any flesh to that broad enabling statute. We kind of make it up as we've made it up as we go along. I want to be careful because there are some policies and procedures, but there are others where we simply do not have written policies and procedures. And I think it's incumbent upon us to review those ordinances, to provide greater direction, and to the extent where the intention of the legislative branch is to provide broad discretion to the executive branch, that the executive branch needs to establish, written policies and procedures so that everybody that's impacted by those, residents, visitors, guests, businesses, et cetera, have some clarity so that you don't run into this issue of arbitrary and capricious regulation.
Yeah. So, and if you're looking for that, I mean, if you want to see like how good practices, in my mind, how good practices would work, although the Comprehensive Planning Act has any number of problems with it, it's poorly drafted. But on this issue, conceptually, it's helpful. How does it work? You say, for example, if you need to get, if one of the things that somebody needs is a use permit, someone has bought property and they say this property is zoned, professional office, and I want to run, a sports massage facility or a physical therapy facility. And that's not clearly listed in the use classifications for professional office. So then you'll have the ability to go to the zoning administrator and say, give me a certificate of use compliance, where you say, yeah, you can do that there. And so, so the way that would work is, in the Comprehensive Planning Act, is you would say, this is the person who has the authority to make the determination, number one, specify who it is. Number two, here's the criteria on which it shall be determined, so that you have objective criteria. And number three, and you can think about this, it has the right to appeal to council. And so if the permit is denied, and this is going to depend, mayor and council, entirely on what the permit is, but in certain cases, if council says, well, we want to retain our control over this, then have an appeal right to council. And you can model that on what's in the Comprehensive Planning Act. But you know, if you've made a clear delegation and here's the criteria, I think that's probably the best way to handle it. I mean, Mac, do you have any, I hate to put you on the spot, but do you have anything to add to that, or permits that you would think of?
I think what you said spot on.
Do
Okay.
we want to take a quick break now? I'm going to have to round, I know we're scheduled till, we actually, 2. The pace we're going, I'm not sure we'll get through the entire agenda.
My prepared comments are much shorter on the remaining topics.
Okay, well, but I actually think these next two, which are, you can somewhat conflate, will take a fair amount of time. I just let everybody know my wife is out of town, and I've got the little furry girl, so I'm going to have to take around noon, a 30-minute break in order to run home and let her take care of business.
And that's fine. I think we have, and you guys can decide how you want to do this. Lunch, I think, is here at 11 o'clock, but I think we had it set, you guys go to lunch at 11:30, and you can have we were thinking like a 30-minute break or a working lunch, however you want. But if you want to, because I know with Folly, you have to go out, so it can be just a 30-minute break, however you want. But that was going to start at like 11:30.
Okay, that's
That's
fine.
fine.
That's
Want
fine.
to start now?
Okay.
Pardon?
You want to start the break now?
It's a little too early for Folly.
Yeah, and I can do whatever. If y'all want to take a quick break now and then come back.
Let's do the 5 minutes right now. Yes, 5 minutes now.
Some of us have got a couple of emergencies at home.
Before we jump to the kind of the conflation of the next few topics, Eric, maybe, you just mentioned this, I'm not sure this is where you want to go, Russ. One additional, it kind of relates to both municipal authority as well as the relative role of council and the mayor and the administrative branch, legislative branch and executive branch. And that's with regard to the administration and enforcement of ordinances. And, the concept of kind of prosecutorial regulatory discretion with regard to enforcement. We have regular concerns here, people express at council meetings on IQ and otherwise, either we don't enforce ordinances, or in some cases, we are too focused on ordinance enforcement. you know, you said the faithful execution, one of the statutory responsibilities of the mayor is faithful execution of laws, but not clear exactly what
Right.
that means. Council passes an ordinance that says this, you know, don't do this thing, this activity is prohibited, which expresses the policy intent. The question then becomes, you know, is a practical matter, administration of ordinances, code enforcement, what have you, to what extent does the executive branch have discretion to give warnings, to, you know, to not enforce rigorously and rigidly a prohibited activity in each and every instance? And, you know, it rises to things like if people are riding e-bikes on the beach, which is prohibited indirectly, then our beach patrol, who have code enforcement authority, their general practice and policy, when they're an agent of the town for that purpose, is to, you know, we want compliance, we'll first give a warning. And we're not going to issue a citation for violation unless they don't heed the warning. Any guidance for us on?
Unless the ordinance is mandatory, there's actually, so two thoughts. One, there's actually a scholarly term for this. It's called, you won't know it's scholarly when you hear it, but this is what the profession, like the academics in local government call it, street level bureaucracy. And street level bureaucracy is entirely that. The idea is you pass an ordinance and then the officers who are in charge of enforcing it at the street level determine how it shall be enforced. They decide, you know, we know this person, let's take an example. You have a municipal code that says it's illegal for your grass to be more than 8 inches tall. And you've got your code enforcement officer out there, 8 inches tall might be extreme, let's say 4 inches tall. It's illegal for your grass to be more than 4 inches tall. You've got your code enforcement officer out in the field. He sees that the yard is overgrown, but he knows the person, his mom's in the hospital or whatever. He's like, well, I'm not going to write this ticket. Generally, that is fine, unless the ordinance says, you know, unless it mandatory says any violation shall, you know, it's just a question of statutory interpretation. The flip side of that, you know, the downside for street level bureaucracy, which is a recognized way of enforcing local ordinances, is that you run the risk of selective enforcement claims, which might arise under equal protection. You know, you're ticketing these class of people, but you're not ticketing that, or you're letting your friends skate. You know, so you want to balance those two things. But, you know, I mean, from a non-legal point of view, but from putting my administrative hat on, you really want to do that because that's how you work with your community, build trust, give warnings, work with people, you know, cut corners. I mean, let's just be blunt about it on enforcement to make sure that you're accomplishing your larger goals. I mean, we had this issue, let me give you just one example on this. Technically, under our ordinance in Sumter, if you violated certain types of property maintenance code violations, that was a misdemeanor punishable by a $500 fine and time in jail. And we had a guy who got to the point where we're like, we're gonna have to throw this guy in jail. And our mayor said, well, if he's in jail, he by definition can't fix the problem. You know, so we decided not to issue that citation because we didn't want him going to prison. We wanted him to fix the house. Y'all, I mean, anyway, just those kind of things come up.
Stephanie, is it correct? I was struggling to go into my memory bank that wasn't working well, that if we issue a fine for money, like a $500 fine because somebody's not doing something right with respect to the rental policy or whatever, for some reason I have a foggy recollection that we don't have the ability to collect or enforce payment of those when those individuals leave the state. Is that correct?
Well, no, I think, and you can comment on this, I'm not sure, the question came up before is in regards to if they're issued the fine and then they just essentially don't pay, how do we essentially set up collection? And the question then became, well, we don't have their social security number, and I don't recall from a municipal court, because we have municipal court here, how can we essentially put it on set-off data, or how do we essentially put a bench warrant out for someone who may be just a vacationer who refuses to give us information?
Yeah, because the takeaway that I'm trying to struggle to recall, the takeaway was that if that individual doesn't agreeably pay the fine,
Right.
we don't have a way to collect it. in
I think we
general.
do. I think you have to go through, and because I don't really, I think I have to confirm this through Sherry. I think there may be a way to be, and maybe you know, Mac, there may be a way to be able to kind of put out a bench warrant on this person, but they have to be certain information we have, and that sometimes they refuse to give us their driver's license. We just don't have the information, the full information to be able to send, to be able to put them, I guess, on a bench warrant, but I'm not quite sure how that, maybe you
Okay,
guys know.
so Eric, with what you're hearing from Stephanie and me, I wanted to pass that on to you because my perception is, and Brad, please step in, that there is a challenge in getting collections of whenever we cite somebody. Do you have any suggestions?
No, it's a recurrent problem that we don't
It
have an
is.
answer to. It's, I mean, just to, like, again, take a non-specific example. If we had a house, your city is not a Kiowa Island type town because you wouldn't have this issue. But if you have a vacant property that is falling into disuse and you're writing tickets to the owner, you know, you have to fix your house. The windows are busted out, the door is off the hinges. You have to do this, and you're writing tickets. And the owner, turns out it's 14 different people because it's in probate and they live in New Jersey and Pennsylvania. How are you going to collect that? Well, it's just a due process limitation. You can't get them. You see what I'm saying? You can't. And this is a really recurrent problem. It's most common historically in South Carolina for property maintenance code violations where you have out-of-state owners. It's going to become a problem under short-term rental regulations because very often the owner of the property and the tenants of the property are not in South Carolina.
Right.
So it's just this essential legal concept of due process. You have to have power over the body of the person to make them pay. And the truth is, you know, there's one more step to this. Even if you have authority over the body of the person under due process, sometimes you can't collect a fine. And what's the remedy at the law? Well, if you can't collect the penalty or the judgment or whatever, then you can order the sheriff to seize their assets and sell them. But, you know, it's not practical. So it's a problem we really have in our local governments is you have a law that says don't do X, you write a ticket for doing X, and then you can't get paid the money that goes with X.
Well, and with some of the issues, the dollar become pretty significant. The practical challenge is the person who's a vacationer and you issue them one ticket for $200. Investing any time and effort in legal fees or staff fees to try to track down somebody and collect $200 that's gone off to another state is.
Is the fine, is it a judgment? Like if they don't show up to court and the fine is issued, that's a judgment of the court? I mean, I guess if you knew where the person lived, you could transcribe it in that county and go through the normal collection process.
Think so.
But to Brad's point, as a practical matter, you're going to spend way more than $200 doing that.
Now, I assume what you could do is if they fail to pay, you could issue, I guess, a bench warrant. And if they came back to South Carolina, you could potentially put them in jail or, you know, but absent that.
Yeah, I mean, historically, the best example of this was parking tickets.
Yeah.
People, you know, cities and towns couldn't enforce parking tickets, and then, you know, they came up with systems. There's now a solution to that through the state departments of motor vehicles which coordinate with each other. But for like short-term rental violations, I mean, I don't want to be fatalistic here, but there's only so much you can do at the local level to enforce these types of laws.
And I think with the short-term rental, I think we have a pretty good grasp on that because we actually write, we write the ticket to the property management company and the owner. We require that the owner provides their information to us. So we typically don't have a problem with collecting that. I would probably venture to say, our problem is if we're trying to enforce anything on the beach and you have just a day timer that's on the beach, and our code enforcement officers go and say, you know, they want to write a ticket, they want their information, they refuse to give their driver's license or something, or they give fake information. That's where we typically may see the problem. But with our short-term rentals, we don't write it normally to the person that's renting, we write it to the property management company and/or the owner.
And for
we're
due
fine with that.
process purposes, because, you know, the advantage there is they have the property here. And so you've got a way to get hooks in them. And typically, I don't know your short-term rental ordinance, but I would assume that you require the property owner to designate a local agent.
Yes.
Yeah, that's the key, designate a local agent. That's why all the corporation statutes require you to designate a local agent. And if, as long as your ordinance says that. I mean, I'm using that as an example. That has come up in our cities and towns that don't have short-term rental ordinances. If you do, then, yeah, just require a local agent and you've kind of solved the due process problem.
Couldn't they, and tell me if there's an issue here, but couldn't they, like the owner, by ordinance, the owner could be required to request some sort of security deposit from a renter, and the owner or management company is not permitted to release that until they get a letter from the town saying there were no citations against this person during the period they rented? That way we've almost got the funds on hand, and then just, it would be more administration to deal with that, but that's another potential way in the short-term rental context.
Yeah.
Any issues you see with that?
No, I think that's fine.
The rental company would hate it. The rental companies would hate it.
Yeah.
Because they're all self-insuring now for any damage. They're not requiring you to put down a security deposit. So if you have rented your house, you'll know this. It's not a great system because they can do significant damage to your house and they're not on the hook for it. The renter is not. And then the agency, you fight with the agency because it's coming out of their pocket. So they hate that. And nobody, to my knowledge, nobody does it. They're all self-insured today. The rental management companies.
I mean, they would also object just on the administrative burden, but
And that's part of the issue now, why even, you know, like we tried to request it when we rented, and they say, we're just not gonna do that, you have to go someplace else. As a renter owner, I think it'd be a great ordinance, but the agencies are gonna be definitely against it.
I mean, in fairness, they're against everything.
They have standing either, because they, but yeah, thank you.
So Eric, I think you have more
Yeah,
presentation
yeah,
for
so,
us.
and this, hopefully, so one of the questions that, that I think I was asked from the agenda is, what about police power behind the gate? And as a general matter, I think the gate doesn't affect your police power. I mean, you can give me specific examples of where you think it might, but, I mean, my view is your police power extends to private property. I mean, if you can tell a homeowner, you know, on your property, you can build a single-family residential house, but not a butcher shop. I mean, just to take the easiest example, I think you have full police power behind the gate. Now, there are difficult questions, if this is what you want to dive into, about like traffic enforcement behind the gate.
So that is one very specifically, because we do have police powers that include on private property and public property and private property. In the town of Kiowa Island, there's virtually, there's very, very little public property. And, you know, we have a road code that's applicable to private roads. Zoning standards are applicable to private property. So does the town, but the roads are owned, all but 3 miles of our roads are owned and maintained by private property owners, the community association. Does the town, for example, could we establish a speed limit is 25 miles an hour within the municipality's jurisdiction unless otherwise posted? Do we have that? Would that be applicable to private roads?
Mac, have you looked at this question before? Yeah, I'm gonna, the speed limit issues are confusing because it's deeply state preemptive. What I'd ask to do on that question is, can I dig into that and get back to you?
And so ancillary or related to that would be, could we require as a matter of public safety that crosswalks be put in at all intersections, even on private roads?
I think under the police power, the answer to that question is yes.
Okay.
Doesn't matter that it's a private road. I mean, state law, you can say you have to have sprinklers in your houses. You have to have,
Right.
you know, you can regulate private property. In fact, it's a private road. You can say, you know, you're required. I mean, I wouldn't target it. I would make it a general law. I would say all roads within the territorial jurisdiction of the town, whether publicly or privately owned, shall have these, you know, these crosswalk markings? Are these, pedestrian crossings?
I'm not suggesting it's a path we want to go down, just trying to understand kind of the lines of demarcation on some of this stuff.
I mean, Mac, I want to ask you a lot of questions, but do you see any problem with that? I don't see a problem with it. I mean, someone owns that road, right? Is it Kika, or who owns the road?
It's
I think there's
some,
like resort on some, but
Yeah.
majority, like the mayor said,
Yeah.
it's Kika. I think it comes down to also
Does kind of an extension to this discussion, does Kika and/or the resort have to delegate responsibility to us? And the reason I ask is, I was in North Charleston yesterday, and we were on private property, it was a business, but they had a sign saying, "We have designated authority to the North Charleston Police Department to police this property."
Yeah, I can.
So do we need it, or?
That's
From Kika?
That's already done. Kika has
That is done?
essentially, and then Freshfields also has a sign, but
Okay.
Kika has
well,
done that.
but
that's
you're
been
asking, it'd be, they can. The question is, do they have to give us? And what I'm hearing is, no, they don't have to.
Well, see, this is a question that, like, it depends on how deeply we want to explore it. I think what we probably ought to do, because of the time, is y'all give me some specific questions and I'll give you answers. The problem with traffic enforcement, with that particular issue of traffic enforcement, is state preemption, because the state says, these are the rules for traffic. You cannot vary them locally, particularly on DOT roads. And if you issue a citation, it has to be done on a uniform traffic ticket. And, you could have the
But is that true for just public roads, or is that true for private roads as well? The state.
That's the question I don't know the answer to, because I've had the question, can a city, for example, vary the speed limit on a DOT road or on a county road? I don't know that I've ever had the question on that specific question, like speed limits behind the gate.
So that will go to your street, like Bobcat then? Is your street,
It's owned by Kika.
it is owned by?
It was conveyed. That street didn't have to be, but it was.
Okay.
So, but then, again,
I think, just thinking about it, common sense, I think they could probably regulate that on a private road. Like, for example, if there was one neighborhood that had private roads and the neighborhood decided to post a speed limit of 70 miles an hour, like, in a residential area, and the town thought that was dangerous, and exercising their police powers, they could say, no speed limits on private roads, within this, close to a residential area shall exceed this speed limit.
Yeah,
Essentially.
yeah, I feel pretty confident. I mean, this is instinctive, and so I reserve the right to change my mind. But I agree with Mac at the instinctive level is, you should have the ability to regulate the speed on a private road, and you should have the ability to write tickets for violation of that speed limit. That's not a constitutional question. That's entirely a question of state preemption under the DOT rules, and I just need to look at them because they're complicated.
What about parking then? Because if it's on the road, if there's a parking violation too close to a fire hydrant, is that under our jurisdiction then, or?
You should have the ability to regulate that too, yeah.
but that doesn't, so this is an issue that keeps coming up, but the way I've always understood it and tried to articulate it to others is zoning standards, design standards, parking enforcement and all of that. The municipality has its inherent police powers, protect the health, safety, and welfare of its citizens. And if it has, and it has these applicable to the municipality as a whole, a private gated community or a homeowners association can always choose to impose more restrictive requirements on itself. But they can't relax
I think that's right.
the municipalities' standards.
Yeah, I think that's right. And the way it happens in most gated communities, like when I lived in Columbia until 3 years ago, I lived in a gated community, and our traffic enforcement was done by security guards hired by the homeowners association, but they wrote us uniform traffic tickets. They wrote us state tickets. They were doing that under deputization. There is a provision of law, private security companies, private security guards, that allows you to delegate that power. But it necessarily follows, Mayor Belk, that means the police themselves could have done it. could have written a UTT. I don't know, a UTT is a uniform traffic ticket. What I don't know is who had the authority to set the speed limit in that neighborhood.
Okay.
But I'm confident that once the speed limit is set, you can issue a ticket for violation of it.
Without being constablized, code enforcement officers?
I think the private security company would need to be deputized.
Okay, okay.
But in your case, yeah, and so does Kika have a private security company?
No.
There's a staff.
Okay.
There's a
They've got a
Kika staff.
40-person security department, 5 people who do patrol. They can currently, I believe, is all they can do is essentially issue citations for violations of community association rules.
Well, what we
Yeah,
just
we'll have to dig into that
heard is
question.
that they could do parking tickets then.
They cannot, I do not believe that Kika Security could enforce town ordinances. They can enforce Kika rules and
Is
regulations.
that what it is? Oh, so they can't enforce the town's or?
They cannot.
What about state though? Or?
No.
This underlying issue is potentially being litigated in Isle of Palms now. You've seen the stories that Isle of Palms has hired private parking enforcement. And they have a person in Isle of Palms that's saying that that's an illegal delegation. And I think you're gonna, I mean, they're wrong, right?
They haven't filed a lawsuit yet, but we've written them a strongly worded letter. The Coastal Foundation, the same folks that sued Isle of Palms like 2 years ago and lost at trial on every claim, yeah.
But the point I'm making is that it follows from that, and I've talked to Mac about this, and I think his position is exactly right. It necessarily follows you could delegate Kika to do the same thing, you know? I mean, you could give that.
There is an AG opinion on this specific topic about Kika's private security enforcing the town's regulations that Dennis wrote like in the late 90s, I think. And I think what that AG opinion said is council could appoint them as code enforcement officers, Kika's private security for that purpose. If I recall correctly, I read it like 2 weeks ago, but there is an AG
No,
opinion directly
that's
on
correct.
point.
And the code enforcement officer thing is where it turns, is that under state law, the only person who can issue the uniform ordinance summons is a code enforcement officer. So you have to make that, you don't have to, Mac and I have talked about this. I think you should make the designation, they're hereby designated as code enforcement officers, which gives them the ability to write those citations.
So this is an issue that Stephanie and I were having, so I apologize, guys, and kind of trying to do a little deep dive on this one. So the uniform summons language, the only place I could, well, where Stephanie pointed out, so the only place I've seen it is under the motor vehicles title of the state statute and related to the uniform traffic ticket. And it's kind of it's the last portion of that. And I've been trying to struggle with the concept, does that mean that that's the only way in which a code enforcement officer can enforce any municipal code provision, even though this stuff is just under the motor vehicles title, and the UTT itself has a specific list of enumerated?
That's the way I read it. I think that the uniform ordinance summons is just miscodified. I mean, because the uniform traffic ticket, essentially for those of you on council, that what the uniform traffic ticket is about is if you violate a state, if there's a state moving violation, it has to be written on a uniform traffic ticket. And the uniform traffic ticket has this certain form. Now, if you want to be cynical, why they have to be written on a uniform traffic ticket is because that includes the court administration and assessment cost that go back to the state court system. And so they don't want that money to be lost. But then there are a lot of problems with that in terms of, well, if you've got this UTT, then how do we cite for other violations? And the answer is the uniform ordinance summons, which is a violation of any ordinance other than a moving violation. And I don't know why they put it in Title 56. I don't know the answer to that. But people use it for everything. For violations
I know they do,
of,
but I'm reading it, it doesn't says you may establish. The enabling statute in that title, which is weirdly placed, says you may establish
Yeah.
a uniform summons
Well, and there
citation.
are-
It doesn't seem to require you to do so.
Well, there may be I mean, there are cities that do things like what are called notices of violation. I mean, the advantage, I think the reason everybody uses the uniform ordinance summons is because it has a process, like a jurisdictional process that gives you these rights. There's nothing under state law for something called a notice of violation or a citation.
Okay.
Do you know, are all yours done by uniform ordinance summons if you have a violation of a code ordinance, of an
Yeah,
ordinance?
we issued notice of violations, and we also do the uniform or the summons. Is it under, I know it's a form, but I don't know what.
But the notice of violation would be essentially in the nature of a warning then?
Yeah,
Yeah.
correct.
So
Correct.
that is what I've been, Stephanie and I had a lengthy conversation about that may have been what's been done in practice, whether that has to be done. And where this really comes up is in the context not of going around and seeing a parking violation or something like that, but we have a lot of code provisions with regard to finance and taxation, business licenses, et cetera. We've got building code, related issues. Our ordinances say that the treasurer is the license official for purposes of all the finance and taxation related provisions of the code. I would think that that person has the authority, therefore, to issue a violation, notice of violation, that actually is not just a warning. It says, you have violated this provision of the code. You are obligated to pay this amount.
Give me an example. You have violated what provision of what code?
You haven't paid, you didn't pay your business license fees, you didn't calculate your gross receipts correctly.
Too many cars in a driveway?
That's one I'm trying a little differently. I'm trying to focus first on the ones where our code says, our ordinance says, the license official, who is the treasurer, has the authority to enforce Article 4, which is the finance and taxation article. The idea that somehow, I just find it nonsensical to say that she has to then go to a separate code enforcement officer to issue this concept of a ticket for a violation of the business, gross receipts, business license revenues, calculations of this, audit things, and all of that. It just doesn't make any sense to me.
I think, so two things here. One is, I don't really have a position on whether you could tell someone that they're out of compliance with the town ordinances by something other than a uniform ordinance summons. What I do have an opinion on is that the uniform ordinance summons is how the municipal court gets jurisdiction over.
I understand, I get that.
And so if you want to assert jurisdiction over the person for the violation such that you can hail them into court, you would do it by uniform ordinance summons. And I think that the purpose of the code enforcement officer in that regime, Mayor, you could think of about as service of process.
Yep.
Who has the authority to serve
issue-
the
yeah,
process?
serve, that's exactly right.
And that would be the code enforcement officer. Now, there's nothing that says that you can't deputize whoever as a code enforcement officer. There's no
And
standards for that.
We're going down that process.
Yeah, there's no
as well.
standards for that.
Code enforcement officer.
We have several. By ordinance, we have several people whose titles are, and they are appointed, the mayor appoints the code enforcement officers who are deemed code enforcement officers. By ordinance, building officials and building inspectors are deemed code enforcement officers. The finance staff, which is responsible for administering and enforcing the finance and taxations, haven't heretofore been specifically so deputized. But I was trying to, the conversation I was having with Stephanie is exactly to your point. I see that there is a distinction. There are two separate actions as to issuing and enforcing a violation versus asserting the jurisdiction of the court.
That's right.
And they can be conflated, they don't have to be. So if the finance department says, you violate this ordinance, you owe this amount, then they're obligated to, they're the license official entitled to enforce that provision. if they want the court, if the person doesn't pay and they want the court to then obtain jurisdiction, then you have to issue, somebody has to issue a summons.
I think that's right.
Okay.
So Stephanie, is the beach patrol deputized to give summonses? or-
Yeah, they're code enforcement officers.
So, all right, so is everybody on beach patrol or just Rob?
No, everyone that works, that's designated as code enforcement officers for beach patrol can issue a municipal, they enforce a municipal ordinance, so therefore they can issue a summons.
So everybody on Rob's staff is a code enforcement?
Not everyone, whoever Robin saws, who they've hired to be specifically code enforcement officers.
Oh.
But if their entire staff, which I understand their entire staff is not, they have some that's just beach patrol, but whomever they've hired as code enforcement
Yes,
officers.
yes, yes.
yeah.
All right, so what about, hold on, so what about the beach people, all right?
Island Beach Services,
Yeah,
they're not code enforcement officers.
they're not.
They're just doing
They're just for
umbrellas,
All
yeah,
right,
commercial activity.
So Rob's staff that's in the cars going up and down the beach?
Because Rob's staff, as you know, the town has a separate contract with them for code enforcement of our
Yes,
short-term rental
yes.
ordinance and our other municipal
Right,
ordinances.
right, but
So,
when I'm
yes.
thinking all right, so, but all the people who are on the beach, they're able to, they are deputized to give out these tickets?
The ones that's on the beach, if they're, first and foremost, the ones that's on the beach are beach patrol. Their main responsibility is the safety of people on the beach.
Right.
But they also have the ability, if they're also working as code, if they have help with code enforcement, then yes, they have the ability to write the municipal, to enforce our code, like metal shovels, glass on the
Right.
beach, those
Do
things.
they have
yeah.
to use, my last question, I'm sorry. So do they have to use this UTT that
We do.
Eric's-
We have a specific code book, and when they write a ticket, they use that
That
specific.
UTT
Mm-hmm.
thing?
No, it would be-
It's
it would be
actually
uniform-
uniform
it would be uniform
summons.
ordinance.
Summons.
It's kind of derived from the UTT.
Right,
It's the same-
right, yeah.
it's the
It's our
same
municipal,
article
yeah,
of the state.
but it's the
Got it.
same.
All right, thanks.
process.
So my question is, what is the issue here, the context of this discussion? What is the problem that we're trying to tackle by asking all of these questions? Is it because we are trying to enforce X ordinance or X violation, and we don't feel that we have the authority, or we don't know the process to do that? Or, I mean, there must be some genesis to.
There was, and particularly came up in this concept of, I was focused for a while, because we're doing an audit, and there are some business license related issues that are arising result of that. And some people may not, they haven't obtained a business license, violation, they're doing business in town, violation of town ordinance. They may be late on paying their business license fee, violation of the town ordinance. They may not be paying the amount of gross receipts that they're supposed to, violation of the town ordinance. And I was saying, the Dorota or the staff should be able to send a violation notice to those people, and that isn't a warning, that's actually saying, you have violated, you are required to pay.
Okay, so you're seeking clarification on.
And where it came up is this concept of, well, they had to have one of our two code enforcement officers actually issue the ticket, which for a concept of not paying maybe millions of dollars for, it's not millions of dollars, but several $1,000s. And I'm saying, that doesn't make any sense to me.
Mayor, it should be a bifurcated process. And what I mean to say is, what the business license official, by whatever title they're named here, what the business license official has the authority to determine is whether you have a business license or not. And if you do, how much it costs. That person has the authority to make those determinations, because you've got a business license ordinance. How do you get the person into court? Well, you don't issue them a business license, and then you issue them a uniform ordinance summons for operating without a business license. And every day that they operate without a business license is a $500 fine plus 30 days in jail. And you can continue to issue that notice of that uniform ordinance summons until they get the business license. So the code enforcement officer is never making the determination, how much money do you owe? Have you paid the money you owe? Are you in the right class? They're making the simple determination, do you have a business license or not? And if you don't, and he or she can make that determination, I'm not going to issue you a business license unless you pay on gross revenue X instead of gross revenue Y. But the way you enforce that is you notice them for operating without a license. Does that make sense?
Well, but I'm
'Cause
saying
you have to have an enforcement
That person
tool.
has, I think, the way I read our statute, that person has, the license official has the authority to issue just a notice of violation that is not just a warning, to say, you are obligated to pay. They should pay. If they do not pay, then the question is, what happens then? Is jurisdiction properly? They could, in addition to the amount of unpaid taxes, unpaid license fees, unpaid gross receipts, percentage of gross receipts, et cetera, which may run into the thousands of dollars. They could, if they wanted to, have a fine of $500 a day, which may be de minimis relative to, and the only way you can collect that $500 a day is to, get the municipal court to have jurisdiction over that. But otherwise, could you go to a magistrate, to enforce that? Or do you have to go to the municipal court and issue a separate summons to hail them into court?
Statute says, Section D, service of uniform ordinance summons vests all magistrates and municipal courts with jurisdiction to hear and dispose of the charge for which the ordinance summons was issued and served. So the issue of the summons vests the authority in the magistrate and the courts.
Yeah, and I don't think the business license official has any, I think that your concept of a notice of violation, in that, it's not quite the right concept there. I mean, what the business license official determines is, do you have a business license or not? And.
We're also determining the amount of fees that you're obligated.
Right, which is embedded in, do you have a business license or not? And typically, the way it happens, we filed a motion for summary judgment yesterday in a business license dispute with DoorDash. And DoorDash was the one who appealed it because we said, ultimately what you do, we said you owe a business license, here's the amount. They said, this is a city member. They said, we accept the amount, but we don't think you can require us to have a business license. So we say, fine, until you get this resolved, if we ever catch a DoorDash driver, we're issuing you a citation. Now, DoorDash is a harder question because let's take, what do you normally do for a business? Let's say instead of a DoorDash, it's a convenience store. You got a convenience store that doesn't have a business license because they refuse to pay the amount. The business license official determines they don't have a business license. She notifies the code enforcement, whoever your code enforcement officer is. That convenience store is operating without a business license. They go issue citations. At some point, you have the right to shut that business down. If it's, and so if someone is continuing to operate without a business license, at some point you say, we're going to prevent you, we're going to literally stop you from doing what you're doing. And that may be padlocks on the doors, police yellow tape. I've seen it where they close trouble hotels down. But I think, Mayor, I think what I'm getting at is I think your concept is the primary enforcement mechanism to compel someone to pay notice of violation for operating without a business license. And if they want to dispute the amount, the way they do that is they appeal that under the statute. There's already a mechanism for that.
So, again, it's part of the conversation we're held. I'm kind of thinking my primary residence for a long period of time is DC. And if you get, whether it's tax or from business affairs, a host of others, you may get a notice of violation from the municipality. There's no summons. It's not like the traffic ticket you get would pay this amount, otherwise appear in court to contest. There's no court reference or anything. It simply says, you have to pay this amount. If you don't do so, I think the second step would be potentially hauling you into court or not, placing a lien on property, garnishing wages, et cetera.
That's the important point, is placing the lien on the property, because that's another method of enforcement. You don't have that for business licenses. It doesn't.
I understand for business, but let's just take a hypothetical example that a business on Kiowa Island has been underreporting its gross receipts for years and years. And the amount is hundreds of thousands of dollars. What is the mechanism? It's not, you're not trying to just say, okay, you no longer have a business license. You're trying to go out and collect the multiple hundreds of thousands of dollars.
Yeah, I don't know that there's a way to do that in South Carolina. Because, I mean, the way the business license statute is administered, like if it were property taxes or income taxes, you've got a 3-year statute of limitations, you can go back at them for underreporting. I think that the way the business licenses work in practice is the business license officials accept the number, you give an assessment, and once you've given the assessment, you've kind of lost the ability to go back and challenge the assessment in future periods.
So, Eric, based on the mayor's scenario, we're doing audits on some business licenses. We've discovered that some have underreported. We're going now sending letters saying you need to pay this. If for some reason they don't pay, we keep sending out notices, essentially saying that you owe this, you haven't paid. So the question becomes, at some point, if they refuse to do so, based on our ordinance, because we can probably essentially say that there's language in there about, not underreporting, but I don't remember the exact name, giving false information.
False information.
You could refuse to issue them a new business
Right,
license.
correct. So I'm saying that's the process.
There's no ability to collect the underpayment for,
Well, I think the other ability would be then, could they then potentially, I mean, it wouldn't be that amount, but I guess then just write the summons, have the summons written, but it's just
Well,
up
I
to
mean,
500.
I'm in a little bit of a loss here, because this is, like, if you're talking about state level taxes, there's an administrative procedure. There's a whole title that's about, this is how you deal with taxes. There's nothing like that for business licenses. So ordinarily, what I would suggest in this case is don't issue them a new business license until they pay the arrearage. That's the way I would do it. Now, if you're not happy with that and you say, well, that's not enough, then I could imagine, Mac, I'm going to defer to you on this, but you could institute an action in court and say, you owe us this amount under an ordinance, and you could get a court judgment. And it would be subject, I think, to a 3-year statute of limitations, but you could go back 3 years. But there would be no administrative process. There's no like self-help, like lien. There's no hardwired administrative process like the tax court. But I can't see any reason why you couldn't go to circuit court and just assert this as a claim, you owe us this money.
But, I mean, can't they, or can't we, essentially through the finance director in our ordinance, the business license has already been issued. We're just doing an audit based on last year's information. So we could suspend their license pending revocation hearing, which goes to council. So we can suspend it, which in theory puts that person, well, they can continue working until they have their hearing. But in theory, they can, ultimately, council can say, yes, we agree, and we're going to uphold the finance directors. And essentially, they're out of business because we revoked their business license.
The method by.
Even though we may not get paid, but we have revoked their license.
Yeah,
Through council.
and yes, and the way you would do a suspension or revocation is because the ordinance says you can suspend or revoke if false information is provided in the application.
Correct.
But mayor and council, I mean, enforcement is always the hardest question. It's always the hardest question. Because, how do you, and I can tell you, like the biggest, most sophisticated cities we have still do it the same way. It's an ordinance summons for failure to operate without a business license. So you get to the point that they don't have a business license, and then where you get leverage is those violations. Now, I've never seen it happen that someone, litigation initiated by the city or town in circuit court for past due, underreported business license, but I assume it could happen. I don't see any reason why not.
One of the other fascinating aspects of South Carolina law is the fact that municipalities, I believe, are constrained from imposing a fine of more than $500.
Yeah.
And when this came up in one context, I was sitting in one of the municipal court hearings, and there was a gentleman issued a citation, was throwing a netting over strand feeding dolphins, trying to capture, whether fish or the dolphins themselves. And to my mind, that's such an egregious thing. But the citation notice was for $200, and that was it. And I'm going,
Well, they can get 30 days in jail.
they can. But it seems like that's rare that that's actually, but we don't, it doesn't matter how egregious something is. It just, state statute limits the municipalities.
They do. This is a little bit different example, but on Isle of Palms, for example, there was a gentleman that cut down some trees, and they have a ordinance that talks about those violations. So he was issued the uniform ordinance summons, hauled into court. It was egregious too. We got text messages. He pled not guilty. It was a jury trial, found guilty. The judge made him spend, I think, 1 or 2 nights in jail. And then subsequent to that, the Isle of Palms ordinance says you've got to replace the trees with a tree of this equal size and that sort of thing. And these were big oak trees that he cut down, and they were expensive to replace. And so we brought, as Eric has suggested, a circuit court action against this individual seeking that he pay, I can't remember what it was, $70,000, $200,000. I think this was before I became city attorney, but got the case on the tail end. But that was how they went to enforce those provisions. They didn't do it as a fine, but he was fined. He did spend the night in jail. And then they brought a circuit court action for the monies that they said were owed under the ordinance.
Okay,
Yeah, because the way the limitation is opposed, it's a jurisdictional limit on the municipal court.
yeah.
I mean, that's the way and it's a jurisdictional limit on the magistrate court as well. Because the idea is if it's more than $500, more than 30 days, it's a crime under state law, and that belongs to the solicitor. Or circuit court if it's a civil action.
Okay, got
So-
it. Okay, that's helpful.
Yeah, it's just a jurisdictional question.
So, one of the thorny issues it's kind of behind the gate stuff and public use of public funds for private purposes. You certainly had a number of conversations with Mac about this because he represents both us and Seabrook. We are 2 unique municipalities. Our inherent police powers are to protect the health, safety, and welfare of our citizens.
Right.
Every one of our citizens lives in a gated community. Every one on both communities. So that begins to present interesting issues about then the use of public funds. In these gated communities where every road is not a public road, it's a private road. Every amenity is a privately owned amenity. And it's increasingly difficult. We kind of tried to navigate it below the radar screen, but it presents continuing issues. And I know there's not any guidance kind of in the
Not in South Carolina.
out of South Carolina. And some of the guidance, elsewhere, you look at Attorney General opinion in Florida and Texas, begins to present problems if you kind of, analogize those to us. But in none of those situations where I've read some adverse opinion with regard to provision of trash services, for example, do you have the same situation where every single resident lives in a gated community, and yet the municipality is responsible? So I would think the municipality has to be able to spend funds.
Yeah, it's funny, my watch just told me I need to stand. I've been standing for a while, guys. What's Apple doing here? Anyway, yeah, so let's talk about that. I mean, spoiler alert, we don't have an answer. I can tell you the way I would argue it. And so the question, can you spend public funds behind the gate? It is primarily a question of public purpose, which I know you've heard about. I've seen some email exchanges where you've talked about the four element test, but it's primarily a question of public purpose. you know, you can split hairs here, but generally, everything you do needs to serve a public purpose, including the spending of money. Now, we're going to dig into that a little bit. There are also, in addition to the public purpose, when you're talking about spending public money on private, either gated communities or private donees, is organic principles. There may be equal protection. You know, somebody may say they're getting a benefit in this part of the town that I'm not getting, substantive due process takings. But when we talk about this, I want you to understand the general idea here is that money you raise from one subset of the population cannot be used to benefit a different subset of the population, right? There's no prohibition constitutionally on money you raise from one subset of the population being spent to benefit that subset of the population. Everybody follow me? So that if you, I assume you do not have a garbage collection fee, do you? You do. So providing garbage protection with a fee is completely outside the scope of these constitutional questions, because you're providing a service for a charge. It doesn't matter if they're behind a gate.
But we're not. We're subsidized.
We are and we're not, yeah.
Yeah.
So
Yeah.
if you're, for curbside service, we essentially subsidize that, the town covers.
What's the sort, well, let me go, you know what, but let's come back to that specific example once I go through what I've got here. So what I want to say is that this public purpose cui bono, who benefits type analysis applies most clearly with ad valorem property taxes. Because ad valorem property taxes, by definition, have to be used for general government. You don't have ad valorem property taxes. So you would consider things like, what are your other sources of revenue? And I've put on the slide for conceptual purposes, do y'all know about special tax districts, mids, service charges, user fees, things like that? Has anybody ever explained to you the way a municipal improvement district works?
No.
So a municipal improvement district says you can take a designated area within the municipality, you can impose a special assessment on that designated area that shows up on the tax bill. They pay it as if it were taxes, and that money is used to provide benefits to that area. Everybody follow me? So if you're a developer, and these are the deals that I used to work on, you're a developer and you want to build a new subdivision and it's going to have 1,000 rooftops in it. So in connection with that, you have to build a lot of what would ordinarily be public infrastructure, stormwater retention ponds, roads, street lighting, whatever. You're looking for a way to pay it. You don't want to upfront the cost because you're a developer and you're doing what developers do. So how can you get that paid? The way it works in South Carolina is you can go to the municipality and say, I want you to put an assessment on this property. That assessment is in addition to the property taxes, and it will be used in order to fund those otherwise public improvements. The way it's set up in South Carolina, and this is all going to make sense while I'm telling you this in a minute, is that is actually a government function. The municipality does it. There are other states like Florida and Nevada where there are these entities that do it, or these quasi-public entities called community development districts. But the point is that I want you to understand this is that there are no constitutional issues associated with that, because all of the money being raised is being paid by the very same people who are benefiting from it. And the reason I think this is important for Kiowa Island is because there's nobody outside the gate. Now, I'm not saying that I can tell you there's a case that says that, but I'm saying conceptually, if you're in front of the court and you're saying, we're spending public money behind the gate in a subdivision in the city of Charleston that has 150,000 people, and that's a different question than Kiowa Island with everybody behind the gate. So I'm going to give you some cases on this that I found from other places. Well, I put this up here. Y'all know this better than I do, but I was just curious. I looked at your audit to see where do you get your money from. So when you're saying you're subsidizing the garbage collection, what line item would that subsidy be coming from? Those are your revenues. This is 2023. So Do you know, Stephanie, what line item that subsidy is coming from?
Which one?
So this is the environmental service fee, that's where the collection of the garbage is.
But that's where the portion of the cost that's being paid by charges comes in. But then you say there's a subsidy.
The
Where does
expense side, is it under the same line item, Geraldo?
Yeah, so the cost of the garbage collection is in general government, which is gonna be like 2 million. And then we collecting, for example, like 661. So the rest, so that's what we subsidizing the difference.
Yeah, and I guess what I'm asking is
It's
you,
not a separate line item.
yeah, and you may not paint your dollar bills this way to like trace them, but if someone said, where are the revenues that are associated with that subsidy coming from? Or is it not distinguished?
It's not, it's
Okay.
not distinguished, it's
Yeah.
just in this,
Yeah. So it's probably from business licenses, because that's your largest line item other than, it is your single largest item, is business licenses.
and building permits.
Yeah. And I don't think that business licenses are subject to the same constitutional restrictions that ad valorem property taxes would be. But let's talk about it so we can dig the legal issue apart. You know the four-part test, there's a slide, the four-part test, it's not helpful. I mean, it's one of these things where, I mean, it's helpful in the sense that you should think about these things, but it's not helpful in its use as a predictive tool.
So the challenges with regard to bullet number 2. I mean, because, again, everything we would, there were a number of things we could expend funds on behind the gate. In fact, we do. We actually, all our zoning and all of that all occurs behind the gate. We're providing a wide range of services behind the gate that are benefiting arguably just private parties. The issue that comes up is how do we, there's expenditures we could make where every single one of our residents who lives behind the gate would benefit from that. There's no distinguishing some from the other. But members of the general public who are not our residents, who are not our citizens, would not. And therein lies the conundrum.
Would the tourists and visitors enjoy those amenities?
Yes, they would.
Yeah.
Yes, they would.
I mean, I
But is somebody who is not a tourist or visitor, who is not a guest of the resort, who is not a guest of an owner, that is a short-term rental or something like that, who does not have a tea time, again, a guest of the resort, would not be able to avail themselves. Somebody coming in from Iowa or elsewhere in Dorchester County or Berkeley County or Greenville, otherwise doesn't have any nexus to a property owner or a business here, would not be able to avail themselves of that, the benefits of that expenditure.
But Brad,
How are they
can I
getting on
give?
the island?
Go ahead.
How are they getting on the island?
There-
That's saying
yeah.
they can't. That they can't. That's the issue.
Or I guess if there's example, so I understand, I guess if they're getting on the island, I guess they're a guest.
Yeah.
Either the short-term rental or the
Supposedly,
resort, but
supposedly.
supposedly they're a guest. So I think the question that comes up a lot, and maybe it'll help me put this so I understand, is in relation to public dollars can be from our general fund or it can be from the state accommodation tax, public dollars. Being able to, as an example, the community association, KICA, that has a number of community boardwalks. If we give them public dollars to fix up those boardwalks, granted the boardwalks are for their members, but it's also could be for the guests who are in short-term rentals, use those same public boardwalks.
Every one of our residents, every one of our citizens
Citizens
has access to
has
this.
access to that, as long as they're behind the gate, because in theory, they're invited guests. So the question becomes, could public dollars be used? Can KICA essentially apply for money, public dollars to be able to use to fix up the community boardwalks that in theory will be available for everyone that's invited behind the gate?
My instinct is yes. Now, I mean, I want to say, and I know it's frustrating to council, these questions are made on a fact-by-fact basis. Mac has already shared with you a case where DOT did some private bridge inspections, and the court didn't like that. There was a vigorous dissent in that case, and I think the dissent was right, that, you know, it's, that the fact that some private owners may benefit more than others doesn't really matter. I think that the unique considerations of Kiowa Island are going to be very informative to the court when they get these kind of questions. Because what you're going to tell the court is there are at least two unique factors about Kiowa Island as compared to this DOT case about the private bridge inspections. Number one, everybody's behind the gate. So there's no distinction between your residents. Number two, your revenue side of your budget is largely driven by tourism. I mean, because the businesses that are paying those business licenses, presumably, the reason they make so much money is because of the tourist economy here, right? The reason that you're building, like when you look at those revenues, how many of those are not connected to the fact, like the local option sales tax, that is completely connected to the fact that you're a tourism-driven economy, what determines that. And so I think when you say to the court, like, look, when you're looking at what's the relevant, you know, when you're talking about private versus public, you always want to say, you know, let me take it from a different question. There's two questions embedded here. One is the distinction between a private party and the government. The other distinction is between one class of residents and another class of residents. So for example, if I were the, you know, Darlington County, and I wanted to put on county-wide taxes to build a sewer system, but the sewer system only served one portion of the county. You don't have that issue at all because everybody's behind the gate. The only issue you have is this conceptual idea about how much contribution can a government make to a private party. And I think the answer to that is, you know, it's going to be determined on a fact-by-fact basis, but you want to look at the expenditures. I have a couple of sample cases that I just wanted to share. So you don't need to read all this, but here's a Wisconsin case that says, can the town pay for snow plowing of private roads? And the court in Wisconsin says that's fine because everybody benefits from having clear access roads. The fact that a road may be publicly owned or privately owned, it doesn't matter because the residents, a significant enough subset of the population are using these roads. So Wisconsin Court of Appeals said it was fine to use public money to plow private roads. The Court of Maine went the other way. They said the maintenance of taxpayer expense of privately owned roads, and the context of this was snow removal and maintenance of the roads. So you have two courts, exact same question, went the different way. But I found, and this is why I explained the way MIDs work in South Carolina, is this question came up. This is a Maryland case. And the question there was, if there is a tax assessment within this neighborhood, and that tax assessment is used to benefit the neighborhood, does that serve a public purpose? And the court said, yeah, that's fine. Because the people paying the fees are the ones benefiting. There's a match between the revenues and the expenditures. And so my instinct, I'm not going to answer a question on this, but my instinct is Kiowa Island has much more ability to spend public funds, quote, behind the gate than the typical city or typical town would. But when you make those determinations, you want to have legislative findings that explain what that benefit is in terms of the tourist economy, in terms of the nature of the community.
And that's helpful guidance, Eric, but you know, where we want to look going forward. I mean, these issues have kept, there's been this kind of, in my view, arbitrary line drawing between services provided behind the gate versus infrastructure. Mm-hmm. And if, for example, the town were either to negotiate the purchase of or through condemnation, got a piece of property somewhere in the middle of the island where we wanted to have a public park, you know, pickleball, et cetera, or whatever, that would be accessible to every one of our citizens, residents, and visitors and guests, but it would not be accessible to members of the general public who are not those people.
I want to be careful, but I think that's okay.
Okay.
I have a hypothetical.
And the reason I think that's okay is because you could build with county money a park that says the park can be used only by county residents. Happens all the time.
Well, but in that case, if it's used by county residents, like when I was in the city of Spartanburg, we were thinking of doing something, but the difference was to say it can be used by city residents at no cost, but we felt we
Right.
could not restrict anyone else from the public, but we imposed a cost.
Yeah, I think that's fair.
So I think the question here is that if someone on Johns Island say, I just want to go to the pickleball court, could we keep them out? Or we can say, okay, if you're a resident, we're not going to charge a fee, but if you're a non-resident, it's a fee? Or are you saying that we can essentially just say, even though it's public money, public facility, you can't use the facility because you're not an invited guest? Or does the town basically open it up by inviting people by building a pickleball court behind the gate?
I don't have an answer to that question, Stephanie, but my instinct would be that it would be okay to say it's open to residents only. Because residents and visitors, I think that would be okay because you have to use a comparative analysis. I think if you try to, tease patterns out of all these public purpose cases that I've read over the years, I really feel like the question is always embedded, well, who is the public? And if your entire territorial jurisdiction benefits from the amenity, then I think that's your public. And that's why, it's kind of a strange thing, like, I don't want this, I hope this doesn't strike the wrong note, but in a place like Florida, the town of Kiowa Island would probably be a community development district that has statutory zoning power, statutory power to provide things like trash, but they're a quasi-private entity with limited governmental powers because the purpose of that entity is for that neighborhood. But in South Carolina, we don't have that device, so we do MIDs, which are run by cities, but you're essentially a town-wide MID. That's why I gave you the background on MIDs, is that I think your relevant public is different than it would be for a place like Charleston or Columbia.
And so then similarly, I think your answer would probably be yes, and maybe even more clearly so. If the town wanted to provide better internet service to every resident, are we better, let's say we wanted to put up a cell tower that the town owned and contracted out the management of that cell tower, and we'd allow co-location from all the service providers, et cetera. I would think we can do that, even if it's behind the gate.
Yeah, I think so.
Even though it's owned infrastructure
Yeah.
by the municipality that is not generally accessible to anybody, random person from Johns Island or California or anybody else that can't go back in and take advantage of that.
Yeah, I would agree, because at one point, when I started, the town was looking at purchasing the utility system, QI utility. But because of reasons, we
Well-
decided not to purchase it.
So I have,
Stephanie, you know that I worked on the first part of that transaction, right?
Oh, you did?
Yeah,
Oh, okay.
when that discussion was going on in 2010 to 2012, when it got started before you came, they did an RFP, and who knows why, hired me to be their lawyer to represent Kiowa Island in the negotiations to acquire the system. And we hired an economic expert, you followed on this, Stephanie, but to estimate the value of the system that the town would pay, we got number X. The owner came back with number Y, and number Y was 5X. And so,
Can we actually take our
Our
30-minute
lunch
break
break.
now, if that's okay?
Yeah, you guys
As
like,
good as any.
Okay.
lunch is ready.
We're back in session.
And the good news is I only have 2 slides left.
Rats.
And then I have a handout. So we can, I think what I'm going to do on these remaining topics, so I've been asked a question about state accommodations tax. For all the analysis of using state accommodation taxes for allegedly private purposes, I think you treat them just like any other tax for the constitutional issues. But I did want to say, you probably know this, how the breakdown goes. 30% goes to tourism promotion. That is almost certainly going to be a private counterparty that does the tourism promotion. Stephanie, how do you do that here? Yeah.
The
Yeah,
council is
which is
designated.
private nonprofit? Yep, that's the way that works. And then the rest is for tourism-related expenditures. The act has a list of permissible questions, and so on are permissible uses. And so you may know this, but last year, they amended the state accommodations tax statute to allow you to use the proceeds for workforce housing. The Attorney General, this is just the most recent time that this question came up, in Hilton Head, we're talking about Josh Gruber and Curtis Coltrane, they asked for this opinion. And they said, so the question was asked, well, if we have this money and we can use it for workforce housing, can we just give the money to a nonprofit? For example, Habitat for Humanity or some other nonprofit. And so this is kind of interesting. The AG said, yeah, we've consistently recognized that public funds may be appropriated. And I think the most important part of that is non-sectarian. That's First Amendment stuff. As long as it's not a religious group, then it's fine. And then they said the ATAC statute does not appear to prohibit dispersing funds to a nonprofit, non-sectarian organization. The Constitution would not prohibit that disbursement. And you ask whether the answer to the question changes if the entity is for profit. We do not believe it does. That's October of last year, the most recent AG statement on that. So I think for the ATAX monies, one of the items on the agenda was, can you give it to private parties? My answer to that is yes. Do the public purpose analysis. And I'm happy to talk about specific examples.
Well, Stephanie raised one specific example, and she was actually kind of using it in the context of using general funds, and that was like for boardwalks owned and maintained by. Oh, okay, community association. My inclination would be not want to use. They can maintain and assess property owners, members of the association, to build and construct and maintain those. But having said that, it would seem like that would be if they wanted to apply for ATAX funding to do that. Mm-hmm. That would seem to be a entirely appropriate purpose, notwithstanding the fact that they are privately owned, because they are used by not only all residents, all members. They're used by tourists and visitors, and probably disproportionately so, because the majority of people on the island at most times of the year, or at least during the summer, are actually not residents,
right,
not property owners. They're visitors and guests. Mm-hmm. And so that would be one specific example.
Right.
Has Kika ever asked us for CTAX monies?
No, they've been reluctant to do so.
Kika has
not for that purpose.
Not for that purpose.
Yes, I'm sorry.
We fund, they've received, at least since I've been here twice, for the maps that they hand out at the front gate to visitors.
In the concern that has been expressed, and I've had more recent conversations with the chair and the COO, is whether, and Stephanie was involved in one of these discussions, is whether that should be rethought. But their view always historically been services or something, but if it's a piece of infrastructure, is that risk having to get rid of the gate? So members of the general public who are not visitors, guests, resident homeowners and property owners would be entitled to access the island because there was the use of ATAX funding for this particular purpose. And that's been the stated concern. My own view, but I know there's conflicting stuff out there, but it would seem to me that is pretty consistent with the underlying purposes of ATAX.
Mm-hmm. Yeah, I think that's right. I was going to say, I can't produce a court case that says this in the way I think about it. But I mentioned earlier, trying to extrapolate principles from the cases. And I think that one of the principles I would extrapolate from the cases is implicit in what the mayor is saying, which is kind of a matching between the purpose for which the money was raised and the purpose for which the money is spent. So let me put this in perspective. If you had property taxes and you have accommodations taxes, and the court's looking at the public purpose of the expenditure of that money, they're never going to explicitly say this in my experience, but they are going to say property taxes are basically about benefiting the general government of the residents. Accommodations taxes, because they're primarily paid by non-residents. And so those are primarily used for purposes of developing the tourist economy. And that matching of revenues and expenses is going to be implicit in the way the court applies the public purpose test. And so I'm just agreeing with what you're saying and putting it in terms of how the cases look at this.
So kind of to take it one step further, if this is a specific example, if the resort was going to build another hotel and there were going to be traffic issues associated with current traffic lanes on the island behind the first gate, could we give the resort ATAX money to improve traffic flow to and about that resort?
I would think so, yes. I would think so.
If they replied for it.
Yeah, I would think so, yeah.
I have
I
another.
mean, Mac, I should say this. Mac is your town attorney. Mac is probably over there thinking Eric's writing checks that my firm doesn't want to cash. And so I want to defer to Mac on these kind of questions. If you're talking to a bond lawyer, they're going to be Mac's not a bond lawyer, but his partners, like if you're to say, we want to do a state ATAX bond to do road improvements behind the gate, Mac his firm is going to have to answer that question. But my instinct is, if you're doing the probabilities, the court's probably going to think that's okay. I mean,
My thought would be because it's so fact-specific each time my thought would be it's so fact-specific each time before we committed to spend a significant amount of funds on infrastructure or road improvements or something like that, it would probably be safe to get an attorney general opinion so that we've at least got some cover on that issue.
Right.
Just because it's a gray area of the law.
But I think, and you're talking about if we were to do a bond, because doing a bond has really more stricter requirements, especially when it comes to public-private or something.
I
But if it's just
think so,
getting
but
money through
even
state
without a
ATAX,
bond, I think
right.
even without a bond, just using ATAX funds behind the gate, like there's potentially an argument that it is helping.
But we do currently use, ATAX funds are used behind the gate because we're giving ATAX monies to entity that operates solely behind the gate already. It's just not, it's for tourism promotion.
Yeah,
rather
maps
than
and things like that, yeah.
But nonetheless, it is, that's where I've struggled to say, is that a distinction with a difference, or should that be a distinction with a difference for a legal standpoint, that they're being used behind the gate for communications, literature, to try to get people behind the gate, but you can't actually use funds for infrastructure that supports the people you're trying to get behind the gate. That doesn't make any sense, intuitive sense to me.
Because Roger does get money for advertising.
Oh, yes, yeah. Yeah.
Yeah.
I mean, I'm with Eric on this. I think instinctively and common sense is, yeah, you probably can, but I think the safest course, just to prevent y'all from spending a bunch of funds and then getting sued and getting told you shouldn't have done that, would be to get an AG opinion specifically on that topic.
Yeah, and if you do that, let me know before you ask for it. Because, I mean, I don't want this to sound wrong. I know we're live streaming, but we have a relationship with the Attorney General's office, and they'll typically call us to talk about these kind of issues. So I'd want to be plugged in. I'm not telling you I can make sure how it comes out a certain way. I'm not saying that. I'm just saying we can have input through our relationship with the AG staff.
I have a separate hypothetical.
Yeah.
Let's say we were thinking about using state tax funds in an area of the marsh that would primarily benefit folks down on the western end of the island because of where the river comes in, and then it would go upriver a bit to marshland that gets further up along, well, you don't know the streets, but would impact primarily one side of the island, the marsh side of the island. One could argue that for instance, if you're doing an oyster bed project, that any beautification or any protection of the marshlands would benefit everybody, including visitors to the, way off in the future, visitors in the island. But it would, from a location perspective, more benefit folks down on the western end of the island. Is there a problem with that?
I mean, so two answers. The first is from a public purpose perspective, protection of the environment and natural resources is a separate and valid public purpose. You're right about that. In terms of in terms of the A-tax money, you would have to ask, does this project serve a tourism-related purpose? You'd have to make the case that by protecting the environment here, here's how we're fostering tourism, basically. Is it a tourism-related expenditure? And if you can make that argument, I think that's probably fine.
Although I might argue that's one better for general expenditure of general revenues for that purpose rather than trying to tie it to one of the A-tax.
And actually.
Because you don't have to then tie it to tourism promotion.
And one of the things that, it doesn't be tied towards tourism promotion. So remember the town, we have various A-tax monies. What we're talking about here is state A-tax, but the project you're talking about, we can probably find it through our local A-tax we do, or the county. Like with regards to the road, Kiawah Island Park, we're a beach walker. As you recall, a number of the projects that we do, we don't use state A-tax, we may use local or county A-tax, but we don't do 100% because we're able to say that the formula that we've used for state A-tax, we would say 70% of it is tourism, so we're able to use one of our restricted funds, which is either local or county, and then the 30% we pull out of general fund. So for instance, a project like you're discussing, once we look at the project, we're able to determine that yes, it has some benefits for the public. We can probably pull 70% out of the local A-tax, and then 30% would be general
All
fund.
right, I didn't realize that there were separate components. That's good to know.
Yes, we have our
Brad,
3 A-tax accounts.
I'm sorry for cutting in, I beg your pardon. So Brad, then this beach replenishing job should be applicable as well, at least our portion.
Well, that's something certainly we're going to present in a memo to the council, that the staff will present in a memo to the council as potential funding sources. But
Right.
yes, I would
Right.
think that because, well, actually, there is, beach renourishment is explicitly an allowed use of state aid tax funds. So I think that one is
should be easy.
easier one. The question, I think, then just becomes from a practical I wouldn't think there's any legal restriction on that. The question is how much of that project we want to finance through state aid tax funds, because the state aid tax committee would meet, they would make a recommendation to council. Council doesn't have to accept that recommendation. Council can ultimately expend those funds however it chooses to do so. What were our tax funds? State aid tax, 1.2 million or 2 million? I can't remember. $2 million. And so that's money that has to be spent on one of the enumerated tax purposes and within a 2-year period. Now, all those monies are currently allocated other ways.
They
And
are.
that would mean that if we're putting, for example, if the project costs $2 million and we said, council want to do all $2 million, that means everybody else that's currently getting
Right, the other 10 entities
Yeah.
do not get.
would not get any that year.
And just remember already through our budget process, we pull money already from, I think Dorota will have to correct me, either A or county, local or county. So we have a beach renourishment fund already that we've been every year. I think this started maybe in 2016 when we did our last, 2017 when we did our last beach project. Council had then approved that so much money gets pulled over into our beach renourishment fund. So we already have a separate
Okay.
line item for that.
Which we could use, we wouldn't have to. We could tap that, or we could tap alternative sources.
Stephanie, kind of two-part question. When we last cut Captain Sam Spit, did we use ATAX money for that, or?
I'm sorry, I don't know, because I wasn't here when that was done.
Okay. then
So I'm
you
not
won't know-
sure how they
you won't know the
funded
second
that.
part. Yeah. I was going to ask, did Seabrook also contribute to that?
But my understanding, that is the town did not, that was not a project that was
town.
financed by the town. It was financed wholly by Seabrook, and they had an arrangement with Kiowa Partners, which owned the land.
And if it's state aid tax, I mean, Stephanie may have told you this, then Turk, the Tourism Expenditure Review Committee, signs off on it. Now, they're not going to sign off on the constitutional issues, but they'll sign off. If they approve the expenditure, that's basically an administrative determination that it's tourism related. So if you run it through state aid tax, then Turk's going to tell you if it's okay or not. For your local accommodations tax, you don't have that. You just make those determinations entirely yourself. So.
And just for correction, Mr. Rhoda just informed me. Our beach renourishment, I said local and county, is local and hospitality that's currently funding our beach renourishment line item.
So you're not using state aid tax for that?
No, for state aid tax, we did, I thought it was local and county, but it's local and hospitality that we use to fund our beach
That's by
renourishment.
statute. You can designate a certain
Correct.
percentage of it to a beach renourishment fund.
Yeah. I mean, that's basically it. The final item on the agenda, and I don't work in the advocacy group, so I'm not, I can't, but I just wanted to hand this out. I know paper, why do we have paper? But if you wanted, so the final item on the agenda was, and we'll just open it for questions, was review of recent legislation. What we do is, every year, you probably already have this. This is the annual legislative report, and the advocacy group pushes this out. Basically, the way we call them advocacy, you might think of them as lobbyists. We currently have 3 lobbyists on staff. We're recruiting a 4th, because we traditionally have had 4. And their whole job is to go to the General Assembly and work on matters that affect local governments. And one of the things they do is every session, they review every bill that gets introduced. They decide whether or not it relates to municipal government. If it does, they put it in the tracking system. And during the legislative session, they give weekly updates. There's a weekly newsletter called From the Dome to Your Home that you can sign up for. How many of you get From the Dome to Your Home now? Yeah, you probably want to sign up for that. And that's just a very short weekly summary. Here's what's going on in the General Assembly. Then at the end of the year, they do this publication. And then I think, I want to be sure, September 25th, so next week, is the Advocacy Initiative Building Day. That used to be called, did you used to go to the RAMS meetings, the regional advocacy meetings? So we used to have these things called regional advocacy meetings where we would travel around the state, and based on the COG district, we would have meetings with all the elected officials in that COG district to talk about what do you want to happen at the next legislative session. Over the years, it got to where those were called RAMs, Regional Advocacy Meeting. We weren't having a lot of attendance, so this year we've replaced it with this Advocacy Initiative Building Day. That's a one-day thing. You can come if you want. The purpose of that is really to develop the legislative initiative for the next year. So that's how you'd follow all this, is through From the Dome to Your Home, the annual report, the annual meetings for developing next year's initiative, and then we have a podcast. And during the legislative session, the podcast will be, here's what happened in the General Assembly this week. In this past year, for me, the most impactful thing was constitutional carry, because now the gun laws in South Carolina don't make any sense. You know, they were, you can have a concealed weapons permit, and if you have one, you can carry a weapon in these places. Then it went to what was called open carry, that passed. That was, if you have a concealed weapons permit, then you can also carry your weapon openly. And last year, they passed constitutional carry, which is basically every God-fearing American has the right to carry a gun wherever you want to And so we're trying to work out how that works now. The way they amended the laws, this is less of a problem. It's one of the few areas in which, because your entire community is behind the gate, it's all private, you don't have to worry about this because it's all private property. You can regulate guns, or KICA can regulate guns within its boundaries. You guys can't really do anything about guns. That's the law. I'm trying to think if there's something on here
Can I
that
ask a
y'all
quick-
want to ask questions
Can I
about.
ask
So
a
we
quick-
can't do an ordinance that we cannot?
Can I ask a quick question on that? I know it's still private property, but what about Freshfields, because it's not behind a gate?
They're
those
private-
roads are-
they're
those roads are
private property owners, so
private.
Freshfields can bar or conceal. They can bar weapons in their
But we
property.
could not issue
You
an
couldn't
ordinance for
issue a
that.
regulation. Whenever you're thinking about these, like, go back to COVID. I'm sorry, let's let Mac.
Okay, so can I be
Yeah.
part of what you're discussing?
I was just saying, that's why we recommended that they repeal the their firearm statute here. And I think there was some confusion on council at the time about it and wanted to talk about it. It may still be on the books, but we've recommended that they repeal it.
It is still on the books, and it was a conscious decision of the council not to repeal, notwithstanding the fact that it's null and void and cannot be enforced. It was kind of sending a signal, no, we're not, that may be the state law, but we're not going to affirmatively remove this ordinance from our, it was, a kind of the, I guess, silent protest on the,
Well, I will express an editorial opinion on this, even though we're live streaming. Our gun laws are ridiculous. And I'm not trying to pick a fight with the NRA, but the way our gun laws are written now, they are absurd. And I'll give you a few examples. I mean, you may disagree. You may be, and forgive me if you're all NRA members, but there was an attorney general opinion in the last 3 months. The weapons law says it is illegal to carry a weapon into a public building, even after constitutional carry. One of the places you can't carry is into a public building. And the question was asked, does this apply to city-owned parking lots and city-owned parking garages? And the Attorney General said, well, let's look at parking lots. A parking lot is not a building, and therefore you cannot ban weapons even in parking lots you own as a property owner. And then they said, and then let's look at the parking garage. What does Webster's Dictionary say a parking garage is? Have you read this opinion, Mac?
I have not.
The opinion says, parking garage, according to a Webster's Dictionary, is a building in which parking occurs, and therefore it is a public building, but to adopt that determination would contravene the clearly established preferences of the General Assembly, so we conclude that you have a constitutional right to carry weapons into publicly owned parking garages, notwithstanding that they're buildings for which parking occurs. And so my answer to this is in South Carolina. I mean, I had a question 2 weeks ago. I'm sorry, I know we're running short on time. And Stephanie, you can get the sheep's crook to pull me off the stage at any time. But I literally had this question. We have a municipality that just built a new outdoor municipal amphitheater. They had a ticketed event. And the question was, could they prevent weapons from coming into the ticketed event at the municipal amphitheater? And unfortunately, it wasn't a building. It's an outdoor amphitheater. So the technical answer is probably no, which is absurd. But they did it anyway, and we'll see what happens. But, yeah.
and that all just applies to municipalities or governmental entities. So private parties
But private
can
parties, yeah,
whatever
any
they
private
want.
party can, you have full control over your property. And I started to say to Stephanie in a sidebar conversation, I always think that it helps when you think about what the government's doing, to think about the government as a regulator and the government as a property owner. And this became really important during COVID. Could you pass an ordinance that said everybody who goes to Freshfields has to wear a mask? And that's a hard question because you're acting as regulator there. But could you pass a policy that says all employees have to wear a mask, or everyone who comes into town hall has to wear a mask? And in that case, you're acting as a property owner, and you have the ability to do that, subject to First Amendment stuff. I see Maribel. The reason I'm saying this is because I thought the same thing should have happened with guns, but our General Assembly has taken the view, even as a property owner, you have to allow people to carry guns, except for into your buildings.
Oh, so KICA cannot prohibit,
They can because they're private.
but so.
Yeah, so a government-owned parking lot or parking garage, even though parking garage is defined as a building, they say that goes, the Attorney General believes that goes against the intent of the legislature.
So on, all of Freshfields is privately owned. So the owner of Freshfields could say, no guns allowed anywhere on Freshfields.
Right. Let's take the opposite. Let's say Freshfield says, if you're a fan of the NRA, come to our store and and openly carry your weapon. And the town said, we don't want that to happen. Freshfields, you cannot allow people to bring weapons into your building. The General Assembly would say, no, we've preempted that.
Who wins that one?
Oh, they would win. Freshfields would win that case.
Okay, but Kika has the authority.
PICA has the ability with respect to property they own, they can exclude firearms.
What about property, any property beyond the first gate?
I'd have to look at what Kika's regulatory, how their internal documents with their residents work, what control they have over the common areas, et cetera. But the basic idea here, I've made it more complicated than it needs to be. The basic idea is a private property owner can determine the use of weapons, the possession of weapons on that property. The prohibition applies to the government passing regulations about carrying firearms. And it didn't mean,
Let me ask a quick question. The beach is public. Well, the state owns the beach, so someone can carry essentially, then go down Beach Walker, which is a public road, and access the beach, the Beach Walker County Park, and have a gun on the beach because the beach is state-owned, even though we manage it. Correct?
presumably, yeah. Yeah, so I didn't mean to get us really deep into guns, but
No, that's,
I think the rest of this, a lot of this stuff that passed last session is just technical stuff like health insurance premium increases, credit unions. I mean, I don't propose to detain us on that. The most important issue for the upcoming session for y'all is going to be short-term rental regulation. Every year in the past 5, maybe 6 years, there have been attempts to introduce legislation that prohibit your ability to regulate short-term rentals, preemptive bills. Airbnb and VRBO and these outfits, they want no local control over short-term rentals. When those bills have made it to committee, our position has been that they have to allow you to regulate short-term rental uses, that they have to allow you zoning control over short-term rentals, and we've won those fights. I think if legislation does pass, it will be essentially that you cannot ban short-term rentals. It may go further and say you can't put a cap on short-term rentals, because no Folly put a cap on. Yeah, it may go that far. The lobbying power on the other side is significant. We have a lot of members of the General Assembly who agree with us that land use is a core power of local government. And so when we go tell you cannot take the ability of a town or a city away in terms of zoning and planning, we typically win those arguments. It'll be interesting to see what happens, and all I can tell you is it'll be introduced and we'll monitor it.
well, the real concern, that would be a concern. I mean, and I'm interested that Mask has taken a position is, legislation that would effectively preempt any regulation.
Yeah.
Of short-term rentals, just like we're dealing with rodenticides. We can't pass any ordinance relating to the matter is void. And I would hope that, because then you get even business license issues become challenging.
Yeah, and the advocacy team tells me that I'm absolutely forbidden to make predictions about the General Assembly because I'm not over there every day and they are. But with that caveat, I mean, I would be surprised if an outright, if they fully preempted your ability to regulate short-term rentals. You have very good arguments on why you have to be able to regulate short-term rentals. I think the way, if it passes, it will end up is essentially to make it as unburdensome on the industry as possible. I think that's where they're going to end up.
Again, the one unique thing about Kiowa is even though the municipality's ability to be restricted, every short-term rental is behind the gate.
Yeah.
And I would think Kika, whether it chooses to exercise that authority or not, could impose whatever restrictions it wanted to.
Yeah. Yeah, that's right.
But we do have some developments that do not allow any.
Yeah, but those are all private restrictions.
They are.
So yes, private parties can, impose upon themselves more onerous restrictions than otherwise, even
Yeah.
if the municipality may be prescribed from regulating. For example,
Specific regime,
what's that?
such as a specific regime?
Either with Kika as the whole regime or any specific regimes.
Like my neighborhood, for example, in our covenants and restrictions that were recorded with the neighborhood says you can't rent out your house for periods of less than 6 months.
And
to
ours is
prevent-
9 months.
Yeah.
Ours is 9 months.
Yeah.
Yeah. And there's no issue with that. There's no issue with that, and there's no General Assembly threat to that. Because the only person who has equal lobbying power to the short-term rental industry is property owners who don't want the General Assembly to tell them what to do with their own property. So if I owned a large apartment complex and I wanted to say no short-term rentals and the General Assembly told me you can't, I would have a lot of leverage over there to say, I'm a private property owner. You can't regulate my use of my own property in that way.
Eric, scope of MASC's kind of authority, responsibility, role, or what you guys do, and this is, I'm touching on the advocacy area, so you may not really be able to answer this. Do you guys simply respond, take advocacy positions on behalf of municipalities on legislation that's introduced, or will MASC occasionally proactively recommend and introduce legislation?
Yeah, we will proactively recommend stuff. I need to be realistic. I think our advocacy staff is very good, but we don't have a lot of leverage at the General Assembly because we don't write checks. I mean, I hate to say it that nakedly, but every year we have an advocacy initiative. We have very good relationships with a lot of the legislators. We're occasionally successful, but the reason I say that is since I can remember, we've had the ability, one of the association's legislative priorities that we've tried to get introduced every year is changes to the annexation laws. It's not relevant for y'all, but for a lot of cities and towns, annexation is a huge issue. And we've never been able to get that anywhere. So we do have a proactive agenda. I want to be realistic about how much we can get done.
Well, and I would would think that there would be the potential, not relying on MASC and its limited advocacy staff to carry the ball, but as a lever, if you could actually get all the other municipalities motivated who may have relationships with various members of the legislature.
And we say every time we do training, the most effective advocacy is when an elected official calls an elected official. And so the best advocacy that Kiowa Island can do is call the members of your legislative delegation and say, I'm on the town council in Kiowa Island, this is what I'm concerned about. I'm gonna, because that's the most effective advocacy. Some cities and towns then add their own lobbyists. Columbia has a lobbyist, Charleston has one, that work with us. But we have a staff of 4, and we do the most we can on this.
And then another scope of role issue, the positions you take, do they have to be ones that are applicable to all municipalities? Can there be a subset? And an example might be if we were interested in, I have no idea whether there's anything we would want to, but the State Beach Management Act. That would have packed only, obviously, coastal communities. Would MASC be part of that process?
It's a judgment call. I mean, typically, yes. I mean, when I say it's a judgment call, we'll ask internally, would any of our members be disadvantaged if this were to pass? If there were, if there's a dispute between one municipality and a county and then we'll get involved. And most recently, it turned out badly through no fault of our own, but the most recent time we did that is we worked very closely with Rock Hill on when they were trying to get the Carolina Panthers training facility put in Rock Hill. When I say it turned out badly, I don't know if you followed the news there, but the owner of the Carolina Panthers had a crying, he walked away. He got mad, walked away from the deal, left a smoking hole in the ground. So that deal didn't work out. But for this purpose, what it was is that Rock Hill and York County were trying to get the Panthers to come build their practice facility there. There was legislation required, and yes, we made the decision, our legislative staff will support that. But, you know, if it affected all coastal communities, I'm confident we would, yeah. It doesn't have to affect all members by program.
Just want to just report out in regard, this is something, well, in regards to that, I'm not sure if you guys are aware, but I think this happened like maybe several years ago. The town did look at bringing in a government affairs person, and at the time, we were thinking about bringing someone in to help with the road situation with regards to the county. We just wanted to have someone to be able to advocate for us at the county level and also at the state level, but due to circumstances and the person we were looking at hiring just didn't work out. So we did look into, we had a couple of recommendations. We did look into hiring, essentially, we call it a government affairs person, but that was basically a lobbyist. And just a side note, to go back to the beach renourishment, through the years of approving budget, the annual budget, we transfer money to that account every year. So to include this current budget that you all approved, we are at $6.7 million in our beach renourishment line item.
Thank you.
And that was the end of the things I prepared for based on the agenda. I did not prepare anything. There were 3 additional items that were, if time permits. They were, what, Stephanie, takings? Yeah, we talked about short-term rentals. Yeah, the revetment
We
project,
talked a
which I,
little bit about that as well.
the only thing I'll tell you, and Mac may have told you this already, the short-term rentals, let's assume there's no statewide legislation passed. I don't know what your local, the only federal case law issue that has developed out of the short-term rentals is the Fifth Circuit, which is like Texas, Louisiana, very conservative circuit, struck down the city of Austin's short-term rental ordinance because their short-term rental ordinance required resident owner. They required that the person who is doing the short-term rental be a resident of Austin, Texas. The policy reason for that was because their idea, the property will be better maintained if the owner is local. There will be someone to talk to if there's a noise disturbance. And the Fifth Circuit decided that that residency requirement violated the Dormant Commerce Clause by putting an undue burden on interstate commerce. And the city of Austin said, we're not discriminating against non-Texans, we're discriminating against anybody outside the city of Austin. And the court said, we don't care about that. It still has an effect on people outside of Texas that is disproportionate. I don't know that that's the right decision. As I say, the Fifth Circuit is very conservative. But when we're talking to people, we recommend that you not have a residency requirement to avoid that issue. And Stephanie, if we don't probably need to go any deeper in this, but you've already said that does your ordinance require a local agent? Yeah, the local agent solves a lot of the problems solves a lot of the issues for why you would want a resident owner, because as long as you have a local agent, then you have someone to work with who can accept service of process, who can accept notice of ordinance summons. That's the only issue that I wanted to raise for you, because I've gotten that question a lot. Cities or towns that say, we want a rule that says the only people who can rent their houses out short-term are town residents. And there's a constitutional question about that.
Well, is there a distinction between, maybe not saying comparing between residents and non-residents, but 4% properties and 6% properties? Because arguably, you could be a resident, have your primary residence there, and then also a 6% property, because that seems to be
same
the
issue.
trend that it's the same.
No, I think that would be, I'm sorry, it's trying to get at the same issue, because if it's 4% property, but I think the difference is that 4% property is available to anybody. You don't have to be a state, you don't have to, how do you say this? I think it's probably okay. Let's just say it for this reason.
What
That
is
that
4%
I
property?
think you have to be
So-
a resident, don't you?
It's an owner occupied, no, I mean, the law's kind of crazy on this, but it's as long as you've provided proof that you intend for that to be sort of your permanent domicile, so you can get that special tax exemption, I think is what it's called, as your primary residence. But like, I've got a case right now at the administrative law court where a Venezuelan citizen is in Berkeley County and is seeking asylum here. And so the question is, should she get a 4% or 6% based on that? So the laws, it doesn't necessarily matter about necessarily residency or citizenship, but more is your intent for that to be your primary domicile or residence to
There's
qualify
also
for that.
a component of it to how many weeks a year you rent it. So I think it's over 10 weeks, you're in the 6%. I think that's the number.
Yeah.
Because we, again, broke through that a couple of years ago, but the amount of rent we were going to get for the extra weeks far outweighed paying the tax, so we did it.
But I think what you're asking me, Mac, is could your short-term rental ordinance say only 4% properties may be short-term rented? Is that your question?
Well, the way it is typically done in the municipalities that either I work with or neighboring municipalities is they have everyone that's 4% is outright permitted to do short-term rentals. The 6% properties, they put a cap on it.
Yeah, I think
That's typically what I've seen.
Yeah, and I think
What is
that's probably
4%
fine
and
even under the
6%?
Fifth Circuit case.
Or an investment property.
Yeah.
Eric, there was one other issue back to kind of scope of municipal authority that I meant to ask and forgot to do so. And it's on any state law court guidance decisions or AG opinions that define the kind of the outer limits of police powers, you know, health, safety, and welfare. And one example that comes up, we, both Kika and the town have an ordinance, have a prohibition on hanging beach towels over railings. It seems to me that that is perfectly reasonable for a community association to pose that regulation on its members. It strikes me it's a fairly attenuated case for a municipality to be regulating beach towels. It's hard to make the nexus that that's actually a legitimate health, safety, or welfare issue. Now, I know kind of quality of life, is defined fairly broadly, but are there any?
We just do it on short-term rentals. We don't do it on regular.
Yeah, Mayor, I don't know the answer to that. I mean, your ability to regulate property maintenance codes is it's pretty extensive. You know, everybody has these rules like no cars on blocks, no parking on the grass. Like you can regulate those kind of things. I think the challenge that I would make if you had the no hanging beach towels is it's a very temporary condition. It's not like a car on a block or, but I don't know the answer to that. And if there are cases, they would be really old cases because those kind of challenges.
And that's just kind of one discrete example, but the issues where it seems to me there should be some nexus to health, safety, and welfare, because that's basically what police powers are designed to address. And it's purely some little temporary aesthetic issue.
Yeah, and I think in that case, for the town, the reason why, as we talked about it, but I was also just thinking the reason why we probably do it and how we run it is because right now it's only in our short-term rental ordinance, and short-term rentals have to have a business license, so we run it as like a business license as part of our enforcement of the business license, and that's why we as a town do not enforce it on regular homeowners, but only for short-term rentals, because in our minds, you're operating a business out of your home, and therefore, we have certain other additional restrictions in terms of running the business out of your home.
Any other questions? Okay.
On that Fifth Circuit case that you were talking about, because I've read that, I agree with you. I don't think it's very well reasoned, but I'm not a judge, so it doesn't matter. But in talking with another lawyer about it, he seemed to think there was some more recent dormant commerce clause case that may have changed sort of the elements or analysis. Are you aware of any?
Follow up on that. I mean, we have this issue on business licenses too. We've got a number of people saying that our business license scheme where do you charge double rates for outside? Yeah, that question's coming up. I'll follow up on that, Matt, because I mean, I want to discount it because it's the Fifth Circuit and the Fifth Circuit does weird things. But if there is case law since then, I'd like to see it. So I'll follow up with you on that.
I think it was, the statement was it was generally the Dormant Commerce Clause analysis. So I think maybe a United States Supreme Court case or
Okay.
something tweaked the analysis that they relied pretty heavily on in that case. Because to my knowledge, that's the only really bad short-term rental case out there.
Yeah.
Do you have anything on takings or
Well,
eminent domain? I know
actually,
you had it on there.
Yes, you did say one thing that I want to make sure I may not have heard you correctly, that gave me some pause, that the state can take from the municipality?
I've never seen it happen. But, and there may well be state laws on various things on this, but under the federal Constitution, the idea is, the point I was making was, the federal Constitution views local governments as just part of the state. So you wouldn't have a constitutional claim if, for example, you're the Department of Administration and the General Assembly takes money and gives it to the Department of Health, Environment, Control. You see what I mean? And in the constitutional view, you're just a department of the state. Now, I've never seen it happen. I was just using it to illustrate the principle. And I'm confident there'd be some state law issues associated with it. I was just making the point under the federal Constitution.
All right, thank you. Any questions from the audience, the community? Eric, thank you for the generous allocation of your time. As always, your insights are very helpful and well appreciated.
Yeah, thank you all very much. I appreciate it.
Thank you.
We are
Stephanie, do we need to do a debrief or
adjourned.
anything? Are we good?